work with the Metro Codes Department, and I'll be presenting the cases to the board for their review in today's public hearing. At this time, we would ask both the folks at the front of the room and the folks in the audience, if you would please silence your phones, your iPads, or any other devices so that the board's proceedings are not interrupted. Thanks in advance for that help. Mr. Chairman, I know you would like for us to extend a special thank you to our hosts today, the Metro Nashville Public Schools and their Board of Education, for allowing us to use this space other than our normal space, the Sunny West Conference Room, which is, of course, being prepared for early voting here at the beginning of the early voting season. We're delighted to be here, and we're very thankful to the staff who's gone out of their way to accommodate us.
Yes, this is not the school board, despite the background, but we are very grateful for Dr. Joseph and his staff allowing us to be here for our annual meetings first Thursday of the month. So thank you.
For members of the public, in each of today's public hearings, the board will review correspondence that's been submitted both in support of and opposition to each of the cases. The board also reviews correspondence and recommendations that have been submitted by other government agencies and, in some cases, elected officials who are interested in the cases. In today's hearing, staff will present site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff's presentation, the appellant will have the opportunity to present his or her case. Today, we will ask the appellants to come forward and take seats here at the front table, and when it's time to address the board, just use this microphone. At the conclusion of an appellant's presentation, the board would hear from any others in the audience who wish to speak in support of the appeal that's been presented. If the appeal, in fact, has opposition, the board would then hear from those parties. After opposition presents its testimony, the board would hear from the appellant again with any rebuttal testimony that he or she wishes to bring. Under BZA Rules of Procedure, the appellant has 5 minutes for a presentation if there is no opposition present. In contested cases, BZA rules allow for 10 minutes to each side to present its testimony. Should the appellant wish to use rebuttal testimony, it's imperative that that person save time out of the originally allocated 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on the case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, namely Section 17.40.180. All the section numbers to which we refer today come from the Metro Zoning Code. That applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January the 1st of 1998. I'll introduce the entire Zoning Code and make it part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for Metro's Channel 3, it's imperative that anyone addressing the board come forward and speak into this microphone. All speakers should identify themselves by name and address and then make the desired presentation. The Metro Code requires 4 of our 7 board members in order to establish quorum. The code also requires at least 4 affirmative votes in order to grant an appeal. In the event that 5 or more members are present, and the appeal fails to receive 4 affirmative votes, then the case remains on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to the Chancery Court within 60 days of the hearing date. Additionally, an aggrieved party may file a motion for rehearing within 60 days of the original hearing date, pursuant to the terms of BZA rules and regulations. After that time elapses, the board's decision becomes final and no further action can be taken. For the appellants, if your appeal is granted, you are in fact required to obtain the permit for which you have applied. A permit must be obtained within 2 years for a board approval to remain valid. After such time, an applicant must begin the process anew. It should be noted that if any false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the Board of Zoning Appeals. Mr. Chairman, I submit that all of the cases for today's agenda have been filed in the proper order. All the appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. 3 preliminary announcements from today's docket. First, case 2018-53 involving the property at 2124 Wooddale Lane has been deferred indefinitely. Second, case 2018-61 involving the property at 528 Harpeth Trace Drive has been deferred 1 meeting. That will push it to May the 3rd, which is our next meeting for the Board of Zoning Appeals. And finally, case 2018-99 involving the property at 147 Elmhurst Avenue has also been deferred one meeting to the May 3rd docket. Again, that's case 61, case 53, and case 99, all deferred. Our board utilizes a consent agenda. One board member reviews the record for each case prior to today's hearings and identifies those cases where the appellants have met the criteria for their requested action. If the reviewing board member determines that testimony in the case would not alter the material facts, then that case is recommended to the board for approval. We will enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of the consent agenda cases, please raise your hand, and the case will be removed from the consent agenda and then heard in its regular order. Mr. Chairman, as the layout of this room is a bit different than our normal meeting space, I will solicit your assistance in identifying anyone who opposes one of the consent agenda cases. The first such case recommended for consent agenda is 2018-063, involving the property at 2909 12th Avenue South. Board members will remember that this case was heard at our last BZA meeting. Since that time, the appellants have brought together a new site plan, reviewed with planning, and obtained their blessing and their recommendation for approval of the revised site plan. Therefore, it is recommended for the consent agenda in conjunction with planning's recommendation. Second is case 2018-75, involving the property at 204 Donaldson Pike. The third case on the proposed consent agenda is 2018-083, involving the property at 1400 Ordway Place. The next.
Brett was on that one, there's a hand raised for.
On that one. Okay.
Okay, so let's hear that as scheduled.
83, not on the consent agenda. The next case recommended is 2018-85, involving the property at 2769 Fleet Drive, also recommended for consent agenda. The next case on the proposed consent agenda is 2018-090, involving the property at 1403 Corder Drive.
Are you opposed
Are you opposed to 093? I mean,
You're opposed to 075?
That means you getting what you want.
I'd like to get what I want.
That sounds good. We'll keep that on the consent agenda.
Off the consent agenda.
Again, Mr. Chairman, case 2018-090, 1403 Corder Drive, recommended for consent agenda. The next case on the proposed consent agenda is 2018-096, involving the property at 707 Starlit Road. The next case, 2018-097, involving the properties at 1806 and 1808 Pearl Street, recommended for consent agenda. The next is case 2018-102, involving the property at 5272 Cane Ridge Road. And the last item recommended for consent agenda is case 2018-106, involving the property at 731 Summerly Drive.
Oh, you have a hand on that. What's that hand for?
against, okay.
106 will be removed from the consent agenda. Mr. Chairman, as is always the case, these cases that involve planning recommendations on sidewalk cases, any recommendation for consent agenda, with the exception of 75 in this case, are in fact recommended in conjunction with the planning recommendation, as usual.
Sure.
Thus, we're left with the following consent agenda: Case 63, Case 75, Case 85, Case 90, Case 96, Case 97, and Case 102. We would solicit a board motion and vote with regard to the consent agenda.
Oh, we have a question before that.
Yes, sir, we'd like to check on 075, the 204 Donaldson.
Been recommended for consent agenda and subsequent approval of the sidewalk variance.
Yeah, we'd like to.
Against, okay.
Case number 75 will once again be removed from the consent agenda, leaving us with Case 63, Case 85, Case 90, Case 96, Case 97, and Case 102. At this point, we would solicit a motion and board vote.
Okay, those cases that John Michael just mentioned are moved to the consent agenda. Is there a second?
Second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Aye. Oppose? Consent agenda passes unanimously. John Michael.
Mr. Chair, I would note for all the folks whose cases were just approved on consent agenda, you are approved and received the action that you just asked for. You're free to stay, but you're also free to leave if you wish.
So you're saying the principal has released the students for those particular cases? Since
I'll
we're at
save
the
all
school.
school-themed puns for the chairman today.
Yes. Thank you for coming here, and good luck.
Johnson, Davis, Withers, Sledge. Mr. Chairman, as some folks file out, we will note that this is the point in the meeting where we like to recognize the elected officials who have joined us for today's meetings, often based upon cases in their council districts. With that, wish to recognize Councilmember Mina Johnson from District 23 first. Councilmember Johnson.
Good afternoon, Mina Johnson, District 23 Council member. Actually, I was here for the case deferred. I did speak in support of the zoning administration to invoke the permit, so I will come back on May 3rd to speak again because, as you can see, there were quite a few neighbors to speak in zoning administrator's decision, so they will continuously engage in this case and come back in May 3rd. And also there's one case pulled from consent agenda, which was front setback. There's my constituent, he will be wait for his turn and speak. And I think over there we do have a quite established neighborhood. And yes, indeed, the setback is much deeper than legally required, but I think my constituent, he is concerned about moving quite a bit, 20 feet, 25 feet from existing house line. So his concern would be how it would do to neighborhood in the rhythm of the neighborhood. So I hope you would hear from him his concern. And also, it's not related to setback, but I think if you can kind of address to the person if you are to be granted that setback. During the construction, we would like that construction crew to be cognizant of the neighborhood, because sometimes in that narrow street, this construction crew parks on each side of the street and then leaves emergency car or a neighborhood to maneuver in that narrow street. So we would like you to kind of instruct with the condition if you were to approve it. But either case, I would like you to hear from my constituent case. Thank you.
Councilor A. Johnson, so case 106, are you in support of that variance that they're asking for?
I would like you to hear, actually, I have not reached out from the applicant, and generally, I am in support of my constituent. So my constituent expressed the opposition. To me, in this case, the last week's case, it was only less than 10 feet. So it really did not affect the rhythm of the neighborhood. But this case, the way I see the average front setback seems like 25 feet may be a bit much than existing neighborhood. So I am not 100% sure if it's the right decision or not. So it could be somewhere in between, not 25 feet, maybe 12 feet might be appropriate, so it would not dramatically destroy the rhythm of the neighborhood and the front
I think
setback.
from what we see too, it looks like they're just adding a front porch.
Yes,
Like it's not an enclosed space, but it's a front porch.
right. If it's like 8 feet, 10 feet, just adding front porch and really does not destroy the rhythm like average setback. But according to the BZA tracker on the site, it says existing setback 75 feet and asking 25 feet reduction. That's how the language stated. So I just wanted to make sure the variance is not that deep and did not bring the house too close to the street. So I'm okay with it just front porch and really does not like same as the last case.
Right.
The last case is just addition of less than 10 feet, so it does not affect too much. So I just want you to kind of be close attention to the detail, and you would like you to listen to my constituents' concern.
Thank you.
Thank you.
John Michael, the council lady brought up the BZA tracker. Could you tell everyone what that is and how they can use it?
Most simply stated, it's a tool utilized through the Metro government's website, which of course is www.nashville.gov, which allows the public and the council members to track BZA cases by utilizing a map that shows a pin dot indicating upcoming BZA case here, recently resolved BZA case here, see what the result on a recent vote was, see what the request is, gain access to certain documents from the case file so you can at least have an opportunity to know a little bit more about the case without having to come down to codes, meet with us, call and try to inquire. It's available on the website. The BZA tracker is a relatively newly implemented item. We are very thankful to both the planning department with their mapping technology through the GIS division headed by Jennifer Higgs, as well as the ITS department and the always helpful Amy Neal at ITS, who put in a ton of work to create that and make it helpful to our public, to our council members, and hopefully to everyone who does business before the Board of Zoning Appeals.
Thank you, John Michael.
Mr. Chairman, we're also joined by a number of other council members. I saw Councilman Scott Davis from Council District Number 5. Councilman Davis.
Thank you, board members. Thank you, Metro Codes and planning staff and Public Works for working hard and putting in all the time. Got a few cases on the agenda today, but the first ones I want to talk about, case number 094 and case number 095. I think 099 was deferred. If you're familiar with the Fern Avenue area for case 094 and 095, we waived the sidewalks on this street already and also for another case, and we also waived the in-lieu fee. This is that hill right above Dickerson Road, and it's already very narrow, so adding a sidewalk there would not be in the best interest of keeping the width of that road going because of the width of the road. And it would make things more complicated. The board saw fit to, at a previous case on this hill, to let the current builder get out of the side, not able to build the sidewalks, also not paying the in-lieu fee. And this maybe seems kind of selfish. I really do not like the in-lieu fee when it comes to builds in my district, because if the money was able to stay in infrastructure projects in my district instead of going to other places, because they're my citizens that are being inconvenienced by the sidewalk construction or the water construction, or when they pull their legal permits, which we want them so they can pay the codes department. When they inconvenience my constituents, I would love to see, but the infrastructure money and the in lieu fee goes right back into infrastructure into my district, or at least nearby. You know what I mean? If it helps Gallatin, it helps Brett and Anthony and Nancy. I mean, at least, it won't go to, if I'm doing a lot of building in my district, at least I won't see $2 million of the in lieu fees from my district potentially going into a $5 million project in the west end of the county. You know what I mean? If you're going to take my in lieu fee money, at least send it to South Nashville, parts of North Nashville and Madison, where the richest of the rich don't live. So at least do it that way. But please waive the in lieu fee and the sidewalk requirements. Also,
Can I ask you a question? Is there a legislative way to solve that problem that you're describing?
we can, but some of us, and I'm not speaking for the fine young council people here. They're problem solvers, all of them here. It's the ones that you don't see here at times that just kind of want to just dig their heels in and don't want to be compromised. But more of my colleagues were like these fine men and women right here in front of us. Maybe we get some more stuff done for the city. And last but not least, the case of 092 on 1206 Meridian. I've have not seen it. They've not caused any extra problems. But if it's the right house, it's not a new construction. It's a single-family build, and I'm just going to ask you to, if you can, show some mercy, and just have them just be honest and ask for mercy from the board for that case. And may it be, may it be. So hopefully have a wonderful day. Thank you for volunteering your time.
Thank you.
Councilman Davis, thank you. Any questions for the councilman? Thank you.
Mr. Chairman, we're also joined by Councilmember Brett Withers from Council District Number 6.
Good afternoon, members of the Board of Zoning Appeals. I have 4 District 6 items on the agenda. 3 of them are short-term rentals. Let me see if I can find those quickly. Those are cases 2018-74 on Lillian Street, case number 78, 1409 Russell Street, and then there's one more toward the end of the agenda, and that one is 2018-105 on McKinney Avenue. Those are, as far as I can tell, all pretty cut and dry cases like you typically hear. I have been contacted by 2 of the appellants. I am not aware of any specific community concerns about any of the 3, so I don't have any specific feedback to provide on those cases. So I trust your judgment and the appellants to work through that. I do want to speak today a little bit about a sidewalk case, which is 1400 Ordway Place. I will disagree with my District 5 colleague. What I heard loudly and clearly from constituents when I was knocking on doors and talking to voters in 2015, and I continue to hear from my neighbors, is that there's an expectation that as our city is growing, that the development should help contribute to the infrastructure costs to maintain quality of life, not only for those of us who live here, but for our new neighbors. So I am very much in favor of the in lieu fee, unless there are in fact, I'm very much in favor of constructing the sidewalks to begin with, and in lieu is a second best option. For this particular case, this is a new infill structure that's being built at what is a corner lot. The Historic Zoning Commission has already met on that case. There is a historic contributing structure that had existed and sat on what basically had been 2 existing lots, and that contributing structure sat on or perhaps even slightly over the lot line. And so in order to allow someone to build on this lot, the Historic Zoning Commission has already approved a side setback reduction along the 14th Street frontage, which places that new house really quite close to the sidewalk. So that is, I think, already referenced in your materials that you would have. My biggest concern about this area, well, I have 2 concerns. Number one is that we do have a lot of cases in which, in my recollection, if sidewalks were present but did not meet standard, that the appellants were given an opportunity either to construct sidewalks to standard or to contribute an in lieu fee. And from a consistency standpoint, I struggle with the idea that we would allow folks to maintain sidewalks that do not meet standard and not either construct something new or make repairs or do something. I struggle with that from a consistency standpoint. What I am willing to, I have heard a lot from neighbors as well as from the representatives of the property owner. I am willing to concede that my biggest concern for this property is that it is a corner lot where there is a school present and there's a lot of activity at that school in the mornings. Ordway Place at the far end brings us to East High School. In the 1300 block of Ordway Place is Nashville Classical School. We have a large number of parents walking their children to school in the morning. We also have a lot of parents dropping children off and school buses all trying to navigate what is a pretty narrow street, and neighbors have just a lot of concern about how everyone can get in and out of that area safely. So my concern is more about the Ordway Street frontage of this property than the 14th Street side. The 14th Street side, it is a collector avenue, but it does at least have a sidewalk with a grass planting strip with some street trees, and there is a buffered, not a protected, but a buffered bike lane. So I do feel comfortable that that most people can navigate that sidewalk with a small child in hand safely. But the Ordway frontage does give me a little bit more pause. And so that really is what I would like to pull this item, and I can't stay for the hearing, but for y'all to consider that. My feeling is that since we do have an acknowledgement from the planning staff that even the Ordway sidewalk, wide as it is, does not meet the standard, that I would be comfortable with allowing an in lieu contribution for the Ordway frontage specifically, or if the appellant would like to perhaps defer the case one meeting, I would really like to have the planning and public works staff maybe take another look at this one. I just want to make sure that we're not missing an opportunity to make sure that we have an optimal sidewalk on that corner for all of those families with children that are waiting there to cross. So that's what I would recommend there is either, if a decision does need to be made today, to recommend in lieu contribution for the Ordway frontage, or if the appellant is willing to defer at one meeting, and maybe I can have the department heads take another look at that corner. So that's my request.
Any questions for the councilman?
I do, and it's about something that didn't come up but could potentially come up if we allow them to pay the in lieu fee. And we speak about this a lot, and it's about the dedication of right-of-way for future sidewalks. The way I read the council bill or the ordinance, and I'm asking you because you're a council person and you were involved, I read that it's Part E, that the dedication of right-of-way and easements are required.
Mm-hmm.
What is your take on that? Can you tell us what, as a legislative body, you all meant by that?
Sure. I like to quip that everyone wants a sidewalk until it's coming through their yard. And in fact, what we encounter a lot of times with sidewalk projects that is the most difficult about getting the sidewalk installed once we've got it funded and approved is working with all of the homeowners to acquire, if we do need additional right-of-way, to acquire that. And that lengthy negotiation with each and every property owner along the block can add a lot of time. It can add cost. And so it's very, very important that as we have projects that move forward, even renovations, that we I believe, that we go ahead and secure that right away, so that as you have a lot of development that occurs along that street, at some point in time, you will sort of get to that point at which it's possible to construct the sidewalks to new standard. What happened with the legislation is that in an effort to kind of accommodate our existing homeowners is that we allowed that if one is doing a renovation or an addition to a house, that permit would only require the right-of-way dedication. But for new infill, if you have a demolition or if you have just a new infill, that is more people that are coming to the community. And in those cases, we would actually require either the sidewalk construction or the right-of-way dedication. But in either case, it's helpful to the city as a whole to go ahead and have our right-of-way easements lined up so that we can go ahead and proceed with projects. Just for a little bit further down the street on Ordway, Ordway has a certain width from Gallatin over to 14th. And then when you come down this particular block, 14th to 15th, the street actually narrows a little bit. And then when you get to the corner of 16th and beyond, there are no sidewalks at all. And so having heard from quite a few parents in that area, I have a capital improvements budget request for sidewalks, to continue the sidewalks on Ordway Place further into the neighborhood that would help connect not only the two schools that I already referenced, which are East High and Nashville Classical, but also Laughlin Design Center. So we have a lot of families that utilize one or all of those schools. It is conceivable that we get Metro funding to construct the sidewalk, and yet we still have to negotiate with each and every one of these folks along that route to get that in. So that's the idea, is that as we have permits that are pulled for renovations in particular, that we go ahead and secure those right-of-way easements if we need them, if we don't already have enough right-of-way, so that then we can go ahead and install those sidewalks.
Any other questions for the councilman? Thank you.
All right, thank you so much.
Sean Michael, the councilman requested a deferral. Do you want to talk about that?
The case was originally recommended for consent agenda. At this point, it will be up on its regularly called sequence. After we get started with the first case, I can consult with the appellant to determine if they wish, as it after all is their case, to defer or not, to determine whether they wish to proceed or to defer to that later date.
I mean, I would prefer to hear it because I know we have a big docket on the 3rd with 2 more cases from today added to it. I mean, unless there's any additional information, I mean, it was all for planning to review, and, I mean, they have a pretty thorough report. I mean, I think we can talk about those
We'll
concerns
talk to the
today.
applicant when we get there, but we're ready to hear what's on the agenda, so.
Actually, one more council member to hear from, Mr. Chairman. We're happy to be joined by our councilmanic host from here in District 17, Colby Sledge. Councilman.
Councilman Sledge, it's good to be in the 17th District, albeit temporarily, so thanks for being our host.
Thank you for making the trek down to the district. There are 3 items from District 17 on the agenda today. I believe the first one is case 82, which is on Glen Avenue. I believe this board may have heard this case previously, but may have not had the required votes to reach a full decision. I have spoken with the applicants who seem like very nice people. We have gone back and forth on what I think they had a filing issue between just getting it in on time. However, what occurred in the time since is I received about 16 emails from residents in the area, including some very close by, who said they've had a lot of problems. This is a short-term rental permit appeal, who said they've had a lot of problems with quality of life, noise, hours, et cetera. And so I come to you and I would ask that you would deny this appeal. I know that the folks are going to make a very impassioned case if they haven't already, but unfortunately this is probably the case I've had the most feedback on regarding a BZA case, and I feel like it's probably appropriate to deny the appeal. The next one, I believe, is case number, I think it's either 84 or 86 on yours. It's 1009 Caldwell Avenue. This is regarding sidewalk, basically an appeal for the sidewalk variance. There's a good existing sidewalk on this lot already. However, I would side with the planning department suggestion that the applicant pay the in lieu of fee so that we can continue to build sidewalks where we don't have them, and then to dedicate that right of way. And the last one is an issue on Claiborne Street. I think it might be 103. Item 103, this is an applicant who is appealing the denial of a short-term rental permit. She has not had a short-term rental permit before. She got her paperwork in, I think, a day late, and I think you will hear that from the applicant today. And quite frankly, she called me in a panic before she even got the denial because she felt like she had quite frankly, missed the boat, that she had done something incorrect. And so I know that she has given notice to all of her residents. She is applying for a type 1, an owner-occupied permit, and I've spoken several times with her. I would ask that you grant that appeal. I think she has, just frankly, she goofed up on the paperwork, and I think in this case, I'd like for her to have a little bit of mercy. So other than that.
Any questions for Councilman Sledge? Thanks again.
Thank you.
With that, Mr. Chairman, we're ready to proceed with our first case. After a couple of deferrals, that first case is going to be number 2018-69. This is the appeal of Steve Dumas. He's the appellant and property owner at the property located at 1208A as in Adam, Shelton Avenue. It's an item A case involving a short-term rental permit. This is a denial of an application for a short-term rental permit, with that having been based upon prior operation at the subject location. The zoning map shown here shows the RS 7.5 zone property. The aerial photo gives you an indication of the primary house and then the accessory structure to the rear. And from the tax assessor's website, the photo of the face of the property. Mr. Dumas is here. Is there anyone here in opposition to case number 69? Seeing none, Mr. Dumas will have 5 minutes to make his desired case. Please come forward and address the board.
Hey, John, can we hear from codes?
Yes, apologies. I know the board has expressed an interest in hearing from zoning staff with regard to the short-term rental cases first. It's a very good idea. So the code staff, in this case Mr. Osborne, will be able to address the violations that were found that gave rise to the denial of the application before we hear from the appellant. However, the appellant can come forward and take a seat in the meanwhile.
Mr. Osborne, good to see you again. So tell us about this case, what non-permit violations you might have found, or any other information that will be helpful in our deliberation.
All right, so we found out about this one through host compliance. On October 31st, we sent an abate notice, and it was still in violation on December 4th, so I issued a warrant. It looks like that warrant was served around the 21st of December, and the last review on that advertisement is from December. He called me about January 5th to discuss what was going on, and he explained to me that he has a disability. He can't read his mail, or he's got a visual impairment that kind of caused him to fall into that category. Apparently, he has somebody come over and read his mail for him. So whenever that court date came around on December 7th, we dismissed it because it looked like he had blocked his calendar by the time that we had got to write the warrant, but he was still online.
But since it's not online today,
No, sir.
okay. Any other non-permitted kind of complaints?
No, sir.
Okay. Any questions for Mr. Osborne? Okay, thank you.
I have a regular zoning question. I'm just reading where it says non-conforming status of accessory dwelling unit in the RS 7.5 district. Can you explain that to us a little bit?
I can, and I'm going to give you a bifurcated answer. First part, not at issue today, and I think that's the most important part of the answer. Number two, although there will be a question if the board determines, whenever the appellant is allowed to come back and make a new application, zoning staff will have to review the legitimacy of the secondary structure or the accessory structure as to whether or not it is in fact a legally non-conforming residential use at that location. I mentioned, I think, that it's RS zoning at this location. The appellant is aware of that and has already started his own homework to make sure that he can provide the documentation necessary to demonstrate that it is legally non-conforming. That's a determination that the zoning examiners will have to make at a later date. Fortunately, not an issue before the board today. I know that it was mentioned in the application, so thank you for bringing it up, but fortunately for both the appellant and the board, it's just a question of the short-term rental permit application today.
Appellant here?
Yes, let's proceed.
Mr. Dumas, are you present? For whatever reason, Mr. Dumas seems to not be present at this time. With that, we could probably move that case to the heel of the docket, and in the event of any confusion with regard to the location of today's meeting, reset that for a later date if need be, Mr.
Yeah, a
Chairman.
later date, not May 3rd.
Not May 3rd, 10th, 17th, or anywhere in the month of May, presumably, with our large dockets. Mr. Chairman, I was approached by Councilmember Johnson just a moment ago. Case number 106 was a case that she had asked to have removed from the consent agenda. However, after conferring with some other folks, she has since withdrawn her opposition. So unless there's anyone else in the audience here in opposition to case number 106 involving the property at 731 Summerly in Council District number 23, that is one that could be placed back on the consent agenda, and toward that end, we would solicit a board vote on that item.
Yes, the other thing that I would put on there, and I don't know how we do this, but Councilor Johnson talked about construction and the streets and things like that. Could the person be even more sensitive than normal and not have their construction vehicles park on either side of the street and just, so can you pass that along, that that's part of our approval? So. So that has been moved back to consent. Is there a
Second.
It's been properly seconded. Any more discussion on this? Seeing none, all those in favor signify by saying aye. Aye. Oppose? Passes.
Mr. Chairman, with the grand ambition that we actually hear a case today, we'll move on to case number 2018-073. This involves the property at 5008 Greer Station Drive. Kevin Harris is the appellant and owner of that property, shown here on the zoning map. This, too, is a short-term rental case, technically an item A appeal. You'll hear from Mr. Osborne, the zoning examiner involved in this case, then hear from the appellant, Mr. Harris, thereafter. The aerial here shows the subject property, and then the face from the somewhat dated, but nevertheless accurate tax assessor's website. Mr. Osborne.
So this was another one that we found due to host compliance. We sent a letter on December 1st, and it looks like he came into compliance shortly thereafter. The last review that we have from it, there was one in December of 2017.
Okay. Any other non-codes violations?
Not that I'm aware of.
We have a letter in opposition listing 6 things, which I'll ask the applicant about. parties, drinking, fighting, loud music, etc. But you have not witnessed or
I have not
known.
got a complaint about that.
Okay, thank you. Any other questions for Mr. Osborne? Thank you. John Michael.
That concludes the staff presentation. Mr. Harris, please address the board.
I think there may be opposition, right?
Is there opposition here? Okay, there is, so. Please identify yourself for the record and your address, and we'll,
No, not you, sir. You can come up later.
yes, and why you are here.
Good afternoon. Excuse me. My name is Kevin Harris from 5008 Greer Station Drive, Hermitage, Tennessee. Thank you, ladies and gentlemen of the board, for hearing my case today. I'm in front of you today not to give you guys excuses as to why I haven't complied with the permit. Hopefully just more of an understanding and maybe just some mercy at my suspension. I started Airbnb probably about the beginning of the year to kind of see how it worked for my situation. As you guys heard, I live in Hermitage, so I'm not near any convention sites. I'm not close to downtown. I'm on the borderline of Mount Juliet and Hermitage. And I live in my house, so I'm not renting my whole house. I'm just renting one room of my house. So that's how it all started. I did hear about Airbnb in the news. People opposed to it, permits, things of that nature. So I did do some research at that time to see what that was all about. Everything that I was finding at that time had to deal with property that was solely used for rental properties. You know, I didn't understand how that worked in my case since I lived there, and I was only doing one room. Fast forward, other things I had going on at that time, my father has recently died, and so a lot of my free time was spent helping my mom take care of his affairs. They lived in Jersey, and they were together for like 50 years, so it was more like a lifestyle change for her I was helping her with. Get the loneliness kind of got to her because then she passed like 5 months later. And so now my free time was mostly running up north, taking care of their estate, stuff like that, and finding assistance to do things in the eyes of New Jersey law. Fast forward, that brings us to December. Like you mentioned, I did get the letter stating that I was out of compliance with the permits. At that moment, like you mentioned, I did take my listing down to see exactly what I needed to do to get in compliance. Upon that process is when I found the proper permit I need to attain. That what brings me here in front of you guys today. Like he said, I have not listed, I had not rented since then. I think he mentioned there was a review in December, so that's probably the last person that was in there from when I received the letter. Since then, you know, I do have other permits with Davidson County. Now, this one just took me a little bit longer to get my hands around to do it the right way.
Okay, we have a letter here from someone in Hermitage named Wendell Ford, and they list a few things that they're concerned about with your property in particular. Parties that can get out of control, drinking and fighting, property getting trashed, and loud music. So you said you live there. What's going on?
So honestly, I do not know. Maybe if they can point out where that house is. Like I said, there's only one room being rented. There has not been no parties. The neighbors right beside me is an older couple. They enjoy the fact that I was doing it. They were meeting people from out the country. So there has not been any case. I'm sure if you guys can pull police records.
But you were there. You were there when people stay there.
Right.
Okay.
Yeah, and closer reading about this, I think these might be more generic complaints about short-term rentals too. So what type of person comes and just wants a room? Who are these people?
Right. So mainly the audience I get are just people like business people, maybe couples. And I got a lot of older couples, people visiting. So that's why another reason I didn't want to open up my whole house, because I just don't have the time to clean up behind people. So.
Any questions for the applicant before we hear from the opposition? Okay, you'll be able to come back and you'll have some time for rebuttal. So please, if there's someone here and opposed to this case, this is the time to speak now. Yes? Please come forward, identify yourself by name and address for the record.
My name's Andrew Smith. I live at 4929 Scotts Creek Parkway, directly behind the defendant. And I just wanted to come here because I have nothing against the gentleman here, but our house literally backs up to that property, and we're a very quiet residential neighborhood. I mean, and you could literally hear people slamming doors on their cars and everything else because I guess our walls aren't that thick. And I just really have concerns about a rental in my backyard, And I understand he needs to make money, but, lived there 17 years, and we're trying to just have a nice home and, keep the neighborhood kind of calm and quiet, and don't really look forward to having people sitting in our backyard, maybe partying and doing whatever they do. So that's just my concern, is just, the rental aspect. We're so far away from downtown. We're pretty much to the Wilson County line. So I don't get why they would need to be like high demand for a rental in a small residential neighborhood.
So, I mean, have you had parties in your backyard?
Have I?
No, I mean, as your neighbor, because it sounds like he's renting one room in his house, and that doesn't sound like a very big party. So I'm asking if you're
Heard things, but I can't guarantee that it's him. I mean,
Right.
like the neighbor that's beside him, I've heard them quite a bit. But the neighbor, for him, let's say, no, I can't say that I've actually heard, things coming from his house. I just was notified this with a letter, and I was like, oh,
Right.
we got something going on in my backyard. Because literally, if you look at the picture, that tree, that's my yard. So, and, I'm not strong, but I could throw a baseball and hit his house. So
Right.
it's just really, really compact. And noise travels because the houses butt up against each other. So my main concern is 2 in the morning, we're trying to sleep, 3 in the morning, we're trying to sleep and hear something. And plus, where there's no fencing, there, people coming into our yard, there's no definite line barrier there. So that's just basically my concerns. I just, worked hard to, have this house for 17 years, and I don't want to see property values go down due to rentals and, things of that nature. I've heard too many horror stories and seen too many things about it, so.
Right. Yeah, and we're not, I mean, we tell folks this every meeting just about, because there's a lot of folks that, like you, that come and say, hey, I don't like short-term rentals in general, but the city council has passed the rule that says everybody in this county can rent out their personal home as long as they're living in it. As a type 1, generally, I don't want to, generally, everybody has the right to do that, to rent their personal home. And so we're not really talking about that right today, whether, I mean, you could do the same thing. You could have a short-term rental in your home if you got the right permit on time and it was in your personal home. So we're not really talking about that. So if you hear that discussion, it's not dismissing your concern about the possibility of a party house. It really is what do folks have a right to do with there's rights that they have to do with their property. But if you can testify whether or not it's a party house, or that this person in particular has disrespected the rules that they're supposed to follow, then we certainly take that into consideration pretty heavily too.
The complainant that had filed a letter, do you have the address of where he is? Maybe like that could,
Well, the letter specifically says some of the problems associated with short-term rental are, and he lists, and he says, I'm against short-term rental for the property above. Rental property in the neighborhood is not desired. So the person who wrote the letter had no specific complaints about this property owner. It was a sincere opinion about their not liking short-term rentals.
basically like me showing up today
which is
saying,
a
this is my backyard, I really just don't want people hanging out in my backyard. So
Totally fair opinion, and yet probably not what we're considering, because the law allows people to do it.
Okay.
Okay. Is there any like stipulations or any kind of thing where if it was approved, like maybe they could have a barrier or fence or something? I mean, I'm not opposed to him having his place. I just don't want that coming into our yard,
I think the issue with that is he can be out in his backyard anytime he wants to, just
Right.
like you can.
Right.
So we can't, you can't just require somebody to put up a fence because you have close abutting yards.
Well, I've got like
The
this neighbor,
short-term
they
rental
play
doesn't-
basketball and they come in our yard and just everything else. And I mean, I can't afford to put a fence up right now. I mean, I just can't. And I just really have concerns about, that possibly carrying over into our property. And like I said, nothing against the gentleman. It's just, I got notice of this and wanted to state my case. So,
Okay, any more questions from the opposition?
thank you.
Okay, thank you.
Thank you.
Let's hear from the applicant again. See your rebuttal time to respond.
I don't have a rebuttal. Like I said, none of those events had to do with my property. I will address one thing that he mentioned about basketball. I do know my neighbor beside me does have foster kids. So they will have, events and stuff back there, but that's not me. So,
Okay. Any more questions for the applicant? Okay, thank you. We're going to close the public hearing. Discussion.
Oh, I mean, this is to me one of those cases that is in that 0 to 4 range for my thinking, because it, as soon as the applicant found out, the applicant stopped, the applicant came in to try to do things right. So I'm almost inclined to, I am inclined to say, if I see some nods of maybe agreement, that it looks like shortly after the first, when the letter was received in December, maybe around the 10th, that was when the applicant stopped renting, and I'm fine with saying 4 months from the 10th of December, which would put it kind of the middle of this month when he would be eligible to apply for a permit.
I will second that.
Okay, so
if
I
you're
will
making
make-
that as a motion.
Then I will make a motion that the zoning administrator did not err in denying this applicant a short-term rental permit because it was operated prior. Based on the specifics of this case, we determined that the penalty for that will be a 4-month penalty effective December 10th, 2017. And the applicant would be eligible for a permit 4 months from that date, which would be April 10th.
Okay, there's the motion.
And I will second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Aye. Opposed? Passes unanimously. John Michael.
Mr. Chairman, the next case for the board's consideration is another short-term rental case. That's case number 2018-074. That involves the property at 1708 Lillian Street. You've heard from the district council member, Mr. Withers, with regard to that case. Callie Ewing is the appellant and owner of the subject property, shown here on the zoning map near the intersection of Lillian and 18th Street. The permit application was denied based upon prior operation at the subject location. Aerial here shows you the residential nature of the area. From the tax assessor's website, the face of the property. Mr. Osborne has handled the case for the codes department. We'll hear from him first and then from the appellant. Ms. Ewing, if you wish to please come forward and take a seat at the front table.
So this one is a little bit different than the other ones that we've had. They were actually issued a permit back in on June 15th of 2015. However, the permit was not renewed the following year, but they did reapply in August of 2016. After that, that application process wasn't completed. They told me that apparently the fire marshal didn't come out. They were a little concerned that, I think they were misinformed. They weren't sure if he needed to come out to get their permit again. But they did keep operating, so a notice was sent on October 27th of 2017. And it kept operating until February, so a warrant was issued on January 30th of 2018 for continued operation.
So that's the environmental court. What's the status of the environmental court?
That case was dismissed.
You know why?
Legal thought it would be in the best interest since there was some confusion on the fire marshal's part of that.
Okay. Anything else to add or any other non-permitting violations? Let me ask you something. So just briefly tell us about host software and why we got it, how it works, and how successful it's been. Because here's a case, I'm looking at your material or one provided by host, there are 191 reviews. And this property was under the radar screen until host, correct?
Well, they had a permit, so
Right.
many of those reviews were probably legally done.
Okay, so how many were not, do you think?
I'd have to count.
But just ballpark.
I mean, it's probably half, I'd have to say.
Okay. So tell us how host works and why we have it.
So basically what it does is it'll go and pull all the listings from these websites and try and match them up to property addresses.
So it goes to Airbnb and VRBO and all this, and it sees the listings, and it has our database of actual people that have real permits, and it matches. And the ones that don't have permits, you get that information.
Well, all the ones, even the ones that have permits are logged onto the system. It's just they they're marked as non-compliant if they don't have permits, so that
Yes.
they get put in a list of batches to be sent letters that we do follow up on.
So word to the wise, Mr. Osborne and host will eventually find you if you operate without a permit. So get your permit. Any questions for Mr. Osborne?
I do, if we could recap a second here. Did you say from June 15th, 2015 until 1 year from then, they had a permit?
Yes, ma'am. And it looks like they were maybe a month outside of their renewal window whenever they finally came back in to get their permit again.
But that permit wasn't issued.
Right. Yeah, they, like I said, they were confused on whether the fire marshal needed to come out. And I think they did try and contact him, but for whatever reason, that did not happen.
And then a letter, you said a letter was issued in August of 2017?
October of 27,
Okay,
October 27th of 2017. That's when the abate notice went out.
And to your knowledge, what's the last day that you have that it was rented?
February of 2018.
Okay, any more questions for Mr. Osborne? Thank you. John Michael, let's hear the rest of the case.
The appellant will have the opportunity to make their case to the board. Is there anyone here in opposition to case number 74? Seeing none, the appellants will have 5 minutes to take it up with the board. Please come forward and introduce yourself by name and address.
Hi, my name is Callie Ewing, and my address is 1708 Lillian Street, Nashville 37206. Mr. Osborne kind of covered a lot of what we were planning to cover in that we got a permit in June of 2015. We have, so yeah, we got the initial permit and then we forgot to renew it. So we went back in August, so we were about a month late on our renewal process. And when we got our initial permit, the last step, you just went in and you paid for everything, and the last step of the process was when the fire marshal came out and you didn't have to go back. But that had changed in that 1 year, I guess, is what I have subsequently learned. And so when we went in for the second permit, we submitted the initial paperwork and we went through the process. And when we went to talk about the fire marshal, they said, well, since they were out there a year ago, they may look at their records and they may not come back out. And so I called a couple times, but then they didn't come back out. And so I thought, well, I guess maybe we're good. And I should have obviously gone back in to make sure that was good. Second failure would have been failing to go back in a year later and get it renewed. We have paid all of our taxes and done all the other right things, but we have definitely fallen short in the permitting process related to this. So we had the permit. We thought we had it for 2 years. So it was kind of disturbing to learn that we actually had it for a lot less time than we thought we did. We received the notification. So we did not receive the October letter, which is why we didn't do anything about it at that time. The day that we got the notification in February, we immediately started the appeal process. So went down to codes to see what we needed to do. And I commend them. They've definitely changed that process a lot in the last couple of years. It was, the online queue is great. So this time around, we didn't spend all day out there. That was lovely. So yeah, I guess, so our next piece of it was just that we forgot in August of 17 when we thought we needed to go, when I should have gone in to renew, or that's when I thought I should have gone in to renew. And then as soon as we got the notice in February, we went in to try to get a permit. And then we've also subsequently gone to the general sessions related to that, and that was dismissed with court costs, which is what they seem to typically do as long as you're trying to do the right thing. Other notes is that our neighbors are aware and supportive of this. Our guests are typically individuals and couples. We as soon as we got the notification, we started canceling reservations. So we canceled 13 reservations relatively quickly that would have been in our March through June timeframe. And then at that point, our Airbnb account was suspended. So we got our $50 fees from Airbnb for each individual cancellation. Sorry.
Oh, so we've heard, needless to say, probably hundreds of these kind of cases.
Okay.
So you just went and just canceled them on your own yourself?
I think that's how you have to do
My
it.
understanding is from just being here, if you call Airbnb and say, oops, we didn't have a license and all this, they will cancel them for you, and then they don't tag you with the $50.
That would have been much
and-
easier and
yes.
cheaper.
So word to the wise, when that happens, contact Airbnb and let them do it, not you.
Okay, so yeah, we paid a lot of fines on that, and then our account got suspended. So we do actually have a few reservations out there in August that I couldn't figure out how to cancel, and so my plan was to come here and ask for some mercy and hope that we'd get a little, but we've got a couple out there that are way out there.
But they were just too far out in the future for whatever reason for you.
No, they locked our account after we canceled that
right.
many. We can't even get access to
I would
anything.
call them back and just say, hey, Nashville, Tennessee, I came in front of this board and,
Okay.
et cetera, et cetera.
Well, that's it.
Do you have a question?
Yep, that was it.
So, well, thank you for being so open about this process and canceling. And I also realize that, March through June is a very prime short-term rental
Yeah.
with CMA Fest, graduation, spring break, and all that. So
Yeah.
I'm glad you did that. Any other questions for the applicant? Okay, thank you. Close the public hearing and discussion.
This one feels to me in that 0 to 4-ish also, especially since they paid all their taxes and, there's a little bit of confusion on, should you have had a license or not. I think having gone through it, it appears to be, a safe place. It's gone through the licensing process once. So, I'm inclined to say, 4 months from the 1st of February that was when the last time it was known to have been rented.
I think we need to note also that Councilmember Withers said that these were pretty standard, and he didn't seem to have any objection to what we decided about it.
I mean, is
Remember,
that-
this was one of his cases.
Does that seem too much,
I
too little?
think it's a little bit too much.
What do you
And then
think?
there's no relation from me
No,
and
that's
this
fine.
person, same last names. I think that, the people that quote-unquote do the right thing and cancel, and, they really thought that they were operating under, a permit, and they weren't. I know it's obviously their responsibility. I would say 2 months.
Okay. And again, I think the fact that you pay your taxes and you do everything, I think that just goes, that's over and above what we have for most folks. So I do think that weighs in it. So, I'm happy to make the motion that the zoning administrator did not err in this case, and that the applicant is eligible for a permit 2 months after the 1st of February, which would be today.
Motion's been made. Is there a second?
I will second that again.
Motion's been made and properly seconded. Any discussion? Seeing none. All those in favor signify by saying aye. Aye. Opposed? Passes unanimously. You will be eligible to apply for a permit today. We are not giving you a permit. You are just eligible to take all the paperwork back where you know you need to go, and then in the compute. Now, obviously, we say today, John Michael always reminds me that, our meetings don't necessarily magically get back to code, so it would probably be better to at least go tomorrow. So, thank you.
Mr. Chairman, the next case for the board's consideration is 2018-75. This is the previously referenced case at 204 Donaldson Pike. In short, it is a request for a variance from the sidewalk requirements. The zoning map here shows you the overview of the subject property as it goes Donaldson Pike north of the interstate and before you get to Lebanon. The aerial photo of the structure here looks like a regular house, but has in fact been used as a commercial property for a number of years. In conjunction with the proposed expansion, the sidewalk requirement was triggered, hence the sidewalk variance case that's been filed. The site plan gives an indication of the proposed layout. My photographs from a recent rainy day site visit showing the sidewalk as it exists at this point. I believe you already have in your packet, board members, an email from the district council member in District 15, Jeff Syracuse, indicating his support of the variance request based upon the fact that this sidewalk was poured, as he described it, just last year. the view up and down Donaldson Pike at this location showing the sidewalk in question. Although there is opposition present, you have the email from the council member and also the planning recommendation, which has been submitted in advance of today's hearing. The appellant is Williams Fine Violin, the proposed business, Dustin and Nancy Williams, the owners of the subject property. Because there is opposition present, the appellants will have 10 minutes to make their desired presentation to the board with regard to their variance request. After such time, we'll hear from the opponents. If the representatives for the appellants would come forward and address the board at this time.
Can it, just for clarification, the agenda says, or the docket says that on this case, they were asking for a variance, and it says to be allowed to pay into the sidewalk fund. It sounds like this is a street that doesn't allow you that. Is it your understanding that the applicant is willing to pay, and that was what their request was?
I'll let them speak for themselves on that, because there had been some question about that at one point. You also have the planning recommendation where they have recommended precisely that, which is the payment. So I'll let the appellants speak to that more clearly than I would be able to. Sorry for the vague answer.
Okay, please identify yourself and your by name and address for the record.
My name is Dustin Williams, and that's my property that I bought 2 or 3 years ago or so. I'm sorry, I'm a little confused about what's going on. I'm a violin maker. I graduated from the Violin Making School of America in Salt Lake City, Utah. It's a 4-year program, and I did another year's apprenticeship in Canada. I'm the only graduate of a violin making school of that stature in this state. And I opened Williams Fine Violins on Music Row about 14 years ago. And I have a fantastic crew of luthiers and very talented people there. We have outgrown our space on Music Row, which we lease. And we're very excited to find this property because next to it, you see that lovely expanse of empty land there next to it. I don't know if you can see that or not, but we can get that lovely brick house there and then add to it. And we can have up to 6 lesson rooms where we can teach violin lessons. See that empty space there? Lesson rooms, we can have a room where we can do violin classes and small recitals. And we're really excited about this space. Like my shop, we do violins, violas, cellos, and basses, no guitars. In fact, there's only, believe it or not, in Nashville, there's only 3 violin shops in this whole county. And we're the only one that's actually full service. Violins, violas, cellos, basses, bows, lessons, the works. We're the only ones, and so we're real proud of that. But so much to my surprise, I found out about the sidewalk issue, which kind of caught me aback. I didn't know. The problem is, aside from the sidewalk being brand new, it kind of goes up on a little hill. The property does a little bit, and that 150-foot stretch of land there, to move that sidewalk 6 feet in, put grass, and then build another 8-foot sidewalk would require us to build a 150-foot retaining wall, which my builders tell me will cost $70,000 to $80,000. That's more than 10% of the price of my build. And then I find out Monday that there's this in lieu of thing, which I knew nothing about. To $26,700 would be my fee. I'm scared to death. That's almost 5% of the cost of my build. And if that happens, I'm not sure what we're going to do with our plans to have just like I said, we're moving from Music Row out to Donaldson because we have actually a lot of customers, and it's a more mom and pop.
Closer to the Grand Ole Opry too there.
Yeah, exactly. And
Fiddler's one.
Right, and Music Row is kind of changing, honestly. It's kind of turning into condos. I tell people I'm not leaving Music Row. I feel like Music Row is leaving me. And but yeah, the new builder requires to have more show space. And
So tell us about your interaction with your council person, Jeff Syracuse.
Jeff Syracuse. He's all excited about it. The Donaldson Chamber of Commerce is really thrilled because the place was a tattoo, shop, and I think another person wanted to buy the property. They wanted to turn it into a used car lot. So this Jeff Syracuse and the Donaldson Chamber of Commerce, they even offered to do a ribbon cutting when we moved out there, which was really exciting. So, if we can get out there.
So you're in the space now, you're just trying to...
No, it's an empty building. We've got the plan. We're in Music Row right now at 1218 on 17th Avenue South, and we're just waiting to break ground so we can build it.
So the councilman said the sidewalk was put in last year. Do you know exactly? It's about a little over a year old.
In great shape. The sidewalk runs the whole length of Donaldson Pike.
Okay, yeah, I remember when they put that in. Okay. Questions for the applicant? do you have anything else to add? We were going to hear from the opposition, and then you'll be able to come back and have rebuttal. Okay. John Michael, the opposition, please come forward.
You can invite the opposition forward. You'll need to introduce yourself by name and address and make the desired presentation.
My name is Larry Carter, and I'm here to represent my mom and dad who own the property at 204 and 200 Donaldson Pike. Excuse me, I'm sorry, 202 and 200 Donaldson Pike. I'm sorry my dad couldn't be with us today. He's hospitalized, so I kind of got dropped in this in a hurry. The question we have is we're concerned that we're really not sure exactly what they are going to do. I've tried to find out, in the last few days, but I haven't got anything that I need to know. So I need to know exactly about, when the sidewalk variance, what do you mean by paying into the sidewalk variance in lieu of building? And, I need a clarification on that. I think that would probably help us out to make a little better decision.
Okay, so you heard what he said. He's trying to move his business from Music Row out here and then also expand in that empty lot and have a place to have violin lessons, basically.
Right.
So is there anything related to that you're opposed to?
Not that at all, sir. No, I don't have a problem with that.
And then the other piece is we have a new sidewalk ordinance here.
Yes, sir.
So if you do any major expansion to a commercial building or build a new building, this new sidewalk ordinance triggers. And as the applicant said, this sidewalk, you probably know, was built about a year ago. And what the new law says, you have to tear up the old sidewalk and build a wide, basically a grass strip and then a sidewalk. So your sidewalk the sidewalk in front of his building will look different from the sidewalk in front of your parents because there has to be a grass strip between the road and the sidewalk. And he's asking not to do that and not to pay into the fund, which is there. If you don't build a new sidewalk, there's a fund that you pay into to build sidewalks elsewhere. So is there anything that sounds? Yes, please come forward, state your name for the record. And
I'm Treva Carter, and my husband and I are the owner of the property at 202 Donaldson Pike, which is next door.
yes.
I don't believe having his look different from everybody else's property down there is going to look that great.
So you're fine with him keeping the sidewalk as it is?
Yes.
Okay.
Like all the rest of us.
Yeah.
Our taxes paid to have the sidewalk done. Why should we have to pay for it again?
Okay.
Right. Well,
So,
that-
that really helps. Thank you.
Thank you.
Okay.
Appreciate it.
Let's hear from the applicant again. Please come forward. Please identify yourself for the record and address and.
Tim Turner, T-Square Engineering, 701 West Main Street, Franklin, Tennessee. That's basically what we want. We don't want to have to construct it because of the retaining wall and everything else, and he really doesn't want to pay in the lieu fee.
Very good. Sounds like a happy story instead of the world's tiniest violin playing. So here
All
we
right.
go.
Anything
Let's
else?
close the public. Oh, anything else to say?
Dustin Williams again. I know there's this in lieu of fee thing, but.
We heard from your neighbor.
Oh my gosh, that's a lot of money.
We heard from your neighbor. So
Thank you.
Thank you.
Sorry.
Okay. Let's close the public hearing. This was originally on the consent agenda. We have an enthusiastic letter from the council person. So we said that this was just really recently built. That's why I was in favor of this.
Yeah, I mean, and I'm too, and I'm fine with not paying the fund, mainly because it's a city-built sidewalk that is about a year old, and there are severe topographical issues. And, I go back and forth. I mean, we will have cases today that may not have the same type of topography, that may have a different situation. You have over 100 feet. I mean,
And you can see how it goes up a hill. So yes, there need
yeah,
to be
I mean, there's some serious issues, and it's also, to some extent, the level of fee. I mean, a $26,000 tax basically is probably a lot more than the property tax on that property, and it just seems like it's not the right thing to do, especially given the hardship of a $70,000 retaining wall and the topography that would
That being
cause
said,
so.
Well, I would like to say
Oh, yes.
something. I do agree with you all that $26,000 is excessive. There is a hardship. I'm looking at the topography here. It's hard, though, because where do we stop? I mean, other people will not want to pay into the in lieu fee as well. And so that, to me, yeah, it's okay. I just feel we have two people from the legislative body here who maybe could do something to fix that or change the legislation. I don't know. I just don't know how. I want to vote to allow the appeal, but I don't know how to make it fair for others that do not want to pay into the in lieu fee. So I'm just appealing to the two council people that are here, seeing what the legislative body can
That's
do.
why we hear these cases one by one. I mean, this particular case has the enthusiastic support of the council representative, which some of these cases don't, and has a very expensive retaining wall if they were to build the sidewalk to the spec, so.
But I agree, but I feel like I personally can't cherry pick. We have some council people that are fully on board with the sidewalk ordinance and want their constituents to pay into the in lieu fee, and we have some that, and I think that's the minority, that don't agree with that. And so I personally just don't feel comfortable.
But we've had cases with Councilman Syracuse on Lebanon Road, if I remember correctly, that he said pay into the fund. So I think we give the council people the ability to come in front of us and say, this is what I say and this is why. And I don't think he's just very arbitrarily saying, you know, I don't believe in this bill and everyone should be let out.
And yeah, and I mean, I think each case is very unique, and it's you know, it's in this case, it's hard to ask the property owner to do what the city didn't do, you know, and wasn't willing to do, you know, in terms of acquiring that. So I mean, I do think it's a fine line. I do think we, with any new legislation, we're put in a tough situation because we do get all of the problems with it until it becomes fixed, and there are some gray aspects of it. And you know, we've had a council member today that asked us to impose a fee on a piece of property that the planning department and Metro Historic said not to. And I think that's the first time in any of their recommendations that planning has said, hey, we don't want them to pay, and yet this council member believes strongly that it should, and I respect his opinion on it, but you're just going to get a variety of opinions, and I think you just got to hash it out and try to get 4 votes on it.
I think Ms. Carter's comment was the best when she said taxes paid for that sidewalk that's there right now. And as you say, the city was not willing to purchase the property or whatever they had, declare eminent domain or whatever, to put that strip there. And I think that makes this case very unique, and that sidewalk is so new and it was built by the city.
Yeah, I mean, that is the difference in this case versus, I mean, there are other cases that the sidewalk's, you know, in bad shape, it needs to be repaired. That's the time you really got to pay or redo your sidewalk. There are times when, you know, but those that already have some type element of grass strip, I mean, I think this is a case that's worthy of I'll make a motion that we grant the variance for the sidewalk and that we do not require the applicant to pay into the in lieu fund and just see how that goes.
I will second it.
Okay, motion has been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes 4-1. A happy ending to a sweet violin song.
Yeah, good luck.
John Michael.
Mr. Chairman, the next case for the board's consideration is 2018-077. This involves the property at 3067 Genry Drive out in Council District Number 14. Amanda Mincer is the appellant and owner of the subject property, shown here on the zoning map. The request is for a variance from the size restrictions in the RS-15 residential single-family zoning district for the construction of a 30-by-30 detached garage at the property shown here in this aerial photograph. The plan submitted gives some indication of the proximity of the garage to the property lines in the rear of the property. It's referred to the board under 17.12.050A, which is one of the bulk regulations under the Metro Zoning Code. For my recent site visit, the face of the property here, obviously I didn't go poking around in the backyard. Here's the view up and down Genry Drive for the board's consideration. Is there anyone here in opposition to case number 77? Seeing none, the appellants will have 5 minutes to make the desired presentation to the board. Please introduce yourself by name and address.
Hello, I'm Amanda Mincer, 3067 Ginnery Drive.
Ben Rader, 3067 Ginnery Drive.
My husband and I own and live at this property, and we purchased it last year. And it currently does not have any sort of carport or garage or anywhere to store the cars. So we were just looking to build a 2-car garage. We would have preferred attached, but due to the layout of the driveway and the property line and everything else, it looked like it was going to have to be detached. We didn't realize we would run into any issues when we bought the property with the size of the detached property altogether being half of that of the house. When we bought the property, it already has a shed in the backyard that can't be used for a garage. Obviously, it's a distance away from the driveway, and it's just a wooden shed. So we were just looking to get a 2-car garage.
You know, I mean, a 30 by 30 garage is a whole lot bigger than a 2-car garage. So tell me why do you need a 30 by 30 garage? I mean, you're allowed to build a 1,137 square foot building by right. Why do you need a bigger building than that?
Go ahead.
Well, and he may be able to speak to the size a little more, but even though we can build a little over 1,100 square feet detached total, we were told that that also includes the square footage of our existing shed unless we wanted to tear that down. And I tried explaining to codes that our shed is coming in at, I apologize, I don't have the numbers in front of me, a little over 500 square feet, but part of that is just like an open lean-to where the lawnmower is on the side of the shed, but happens to share the same roof. I wasn't quite sure why that square footage would be taken into account for our detached square footage, but our screened-in porch on the house wouldn't be taken into account for our square footage of the house. But so because of that, I don't think we would have a 2-car garage that even if we went smaller, because we already have a shed, I don't know that we would have the square footage allowed without tearing down the shed to be able to build a 2-car garage. Granted, I guess 30 by 30 is more of a 2.5-car garage. My husband enjoys working on his own car. He doesn't do it for a living, and we don't plan on having other people's cars. But just in order to have enough space to not worry about a small 2-car garage where we're going to bang our doors, but that we can also have tools and equipment.
How big is a 2-car garage?
Well-
I'll ask our architect on the board.
I've seen them at maybe 24 by 24, and that's sort of generous, so 576 square feet. That shed is awfully big, 500 square feet. If I may ask, what's in the shed?
We just have, some lawn equipment right now, and also our, any kind of holiday decorations that you might just get annually. And we're currently storing some things for a relative that's in the process of moving.
Would you be willing to tear down the shed if we approve this 30 by 30 garage?
That had come up for discussion that I guess I was under the impression that if we tore down the shed
you
that we
wouldn't need
could
to be
have
in front of us.
gotten a permit. I suppose the shed has been in existence for a while, but it seems in nice shape and, has electricity run to it and is a secure place for our belongings. So we were hoping that we could still keep that in addition to.
And I guess what I'm struggling with here is that, you've got, and again, not trying to solve your problem for you, but you also have, there's a letter, and I don't know from, from 3061 Ginnery Drive, so it looks like a pretty close neighbor. He was really concerned about, having too many accessory dwellings and, and would ask us not to approve it. And so, and I know they're not here, but that's in our record. And so, that in trying to figure out, well, what's the hardship, which, you need to have a variance, that's what I'm trying to understand better is why is it does it have to be a 30 by 30 garage? Because it sounds like, based on just a standard two-car garage size, that you can do that and keep your shed. And I haven't heard the reason a hardship reason that says, yeah, no, I really have to have, more space.
Well, the reason for the
Please
oversized-
identify yourself for the record.
Oh, I'm sorry.
Did you?
Ben Rader.
Ben Rader, okay.
3067 Jenner Drive. You had asked about what's in the current shed that's on the property. A lot of the items that are in there were from our previous residence where we had a garage. It was a single-car garage, but with, a toolbox with tools, all the lawn equipment, this, that, and the other, it was just barely room enough to fit one single vehicle into. And that was the reason for stating the 30 by 30. Once we get, 2 vehicles in there, a lawnmower, a riding mower, a push mower, all the lawn equipment, toolbox, just various different things that either I may use for the yard or for working on the vehicles, so that we're not having to pull up to a certain spot and just wiggle our way out to get around whatever equipment may be in the garage.
And if I may add, we definitely wanted to be tasteful about it in a matching brick front, one story, obeying any, of course, variances about how far it needs to be away from the fences. And I believe there's a percentage of total square footage that can't go as per the property, and we're nowhere close to that, I'm told. So, and this is the first we're hearing that so far. The only feedback we got was from a few neighbors that were in support of it and didn't see any reason why we couldn't, build a garage in our backyard.
So I'll ask the question again. What's your hardship?
Well, I will say that if our explanation so far hasn't been sufficient for why we would need a 30 by 30, then we're definitely willing to come down, if 24 by 24 can be approved. We were just ultimately trying to park our vehicles, so.
But I think, like I said, that's what we were trying to, or I think I'm trying to figure out, and I think I'm hearing my colleagues do the same thing, is I think 24 by 24 you can probably do without coming here. 24 by 24 is, according to your.
You can probably do a little more, actually.
Yeah, according to according to the complaint letter, which I think it looks like they've done a lot of their homework, it says you have a 2,274 square foot footprint, which says you can have 1,137 square foot accessory dwelling, which is what I had written in my notes, and you wanted 1,414. That was the variance total, which I guess is the garage plus the shed. And so, it already seems like you can do a 24 by 26 and stay under your 1137 limit without even coming to us. That's why we're quizzing you on the hardship. Why does it have to be bigger and keep the shed? So, and with as much flexibility and as options as it sounds like you have, that's why we're asking you. So it sounds like you can do an awful lot without coming here. Why is it important for you to come here and ask for something bigger? See what I'm saying? That's just what that's what I'm struggling with.
700.
No, it doesn't let me do 26 by 24.
I thought the shed had came in at 700 square feet, not 500.
I apologize, we don't have this in front of us, but is it listed how much our shed square footage is?
No, I think you just told us that you thought it was.
Well, from just doing the math, if they're requesting 1,417 and you subtract out the 30 by 30 garage, which is 900 square feet, their shed would be 517 square feet.
Yeah, based on what?
Just doing the math.
Yeah, based on what the request is that the code's has given us. They said that you want 1,412 or whatever total square footage.
If I just heard her correctly, it was 1,700 square feet over if we wanted to do it 30 by 30.
What they have written
Noted on
for
our here,
you
okay.
in the permit application, I got it from somewhere.
Oh, yes,
It says, requesting 1,412 square feet. I was off by 5 square feet.
Yeah, this is from the codes department, which you probably got. It's, when it rejected your request, it said you can do 1,337 square feet total. That's what you're allowed. And it says that you're requesting 1,412. So if you had a 900 square foot garage, then that would imply,
512 square feet is the size of the shed. That's what we were deducting from the information we were given.
Well, I guess we may not have a great answer for a hardship, other than we didn't think it would hurt to ask for a little more square footage on our property, but.
and that's fair enough, too.
Any questions for the applicant? Do you have anything else to add?
Sure.
Okay, we're going to close the public hearing. Discussion.
I think they can do what they need to do based on the calculations you guys have discussed. I've not heard a hardship, although I would have been willing to consider that. We do have a neighbor, close neighbor, that's in opposition. I note we also have at least one neighbor that's written a letter in support. But my thought is to just approve what is allowable for the property.
So to deny the variance request?
And to deny the variance request.
I'll second.
Okay, is that a motion?
I'll make that a motion.
Motion has been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously.
A break?
Yep. John Michael, we're going to take a break.
The board will reconvene after a short break. We'll pick up at case 2018-78. This case for the board's consideration is another short-term rental property. This is 2018-078. This case comes to us from Council District Number 6. You heard from Councilman Withers earlier today with regard to this property located at 1409 Russell Street, shown here just between 14th and 15th. Drew Mahan is the appellant and owner of the subject property. This is an Item A appeal, of course, regarding the denial of a short-term rental permit. Aerial photograph of the property and from the assessor's website, the face view. Mr. Osborne has the case for the Codes Department and will brief you on the details of the case.
All right, so this one was issued a host notice on 10/27/17. Previously, it did have a permit issued on 6/12/15, but the permit was not renewed. It was still advertising and operating as of 1/30/18, so a warrant was issued, and it looks like the advertisement was removed probably around February 10th. Looks like it went to court on 3/14 and was dismissed.
Okay, is there any other non-permitted, so they had a permit and then just didn't renew? That's kind of where we are?
That's what I understand. I had brief communications with Mr. Mahan. I was not at the court date, so.
Okay, so the permit was first issued 6/12/15?
Yes, sir.
And then expired 2 years later, is that what you're saying?
Well, it expired the following year.
So it never renewed, okay.
Right.
Okay. But because of host, you have evidence of renting?
Yeah,
during.
it never stopped.
So how many, since the year of the permit and forward, how many times do you think it was rented, kind of ballpark? Because
Since it expired, it looks about 110.
Okay, 110 times.
And did I understood you to say you sent a letter in October and it was still renting in January of 2018?
In February, I believe, as well.
Okay.
And do you have any other complaints not related to having a permit or any other information that we need to know?
We did receive a complaint that the day the letter was sent out that they did not have a permit.
Okay, but that's not having a permit complaint. Any other things that we might need to know about this case?
That's all I can think of.
Okay, very good. Any questions for Mr. Osborne? Thank you. Okay, John Michael, help us see who's next.
Is there any opposition present for case number 78? Seeing none, the appellant will have 5 minutes to make the desired presentation to the board. Please just introduce yourself by name and address.
Good afternoon. I'm Drew Mahan at 1409 Russell Street. I received a permit for a Type 1 owner-occupied permit in May of 2015. We were given the permit and placed it away with our important household documents. In early February of 2018, we received a court summons from Environmental Court, which really caught us off guard. We had not received any notice that we were not in compliance prior to this. The day after receiving this notice, I immediately went to Codes to try and figure out why we were being summoned to court. I was informed at Codes that it was a failure to renew violation, which led to this BZA case. Upon hearing this, we immediately removed our listing from Airbnb and canceled all of our upcoming reservations. On March 15th, our case was dismissed in Environmental Court. They informed us that we were sent a violation in late October, which we never received. We would have taken action to correct this violation had we received this notice. I have all the proper documentation in order to obtain a brand new permit and or renew if the board gives me the opportunity to do so. We just want to be in full compliance and make this right. Thank you for your time.
Are you paying all your property, all your?
We have paid, yes.
Hospitality tax and
We've
sales
paid
tax?
all of those in the past, yes.
Okay, any questions for the applicant?
And why, again, didn't you renew after the initial year?
When you leave the board or the codes office, they give you the permit, and there's nothing on there that says you have to renew the permit as far as an expiration date. So we just thought as long as you own the property, your permit is good.
Any other questions for the applicant? Anything else? Okay, thank you. Let's close the public hearing. So this is a case in District 6, and we talked about that basically he got the permit and then did not get the notice to renew, and here we are.
Well, I want to remind you again that Councilmember Withers said that none of the 3 STR cases in his district were a big worry to him.
A big worry, okay, yep.
Yeah.
So, I agree with Councilman Withers on this, and this is not a big worry to me either. Paying back taxes, trying to be compliant, and being very open about what happened too. So I would move that, what was the date of the violation?
2/19 was the last day that it was known to be rented. I think the letter came 2/19, and he said it came down immediately. So, or that was when the summons was received. So,
okay.
To me, that
Application date is February 9th, so I'm not sure where the 19th date came from.
oh well, oh that's
Are we
true.
using the February 9th date?
Well, yeah, I would say the 9th would be. a
Okay,
better
we'll use
date
the February
because-
9th then. Okay, well, I move that the zoning administrator did not err in this case, and that the applicant be allowed to apply for this permit on April 9th.
I'll second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye, opposed, passes. John Michael.
Mr. Chairman, the next case for the board's consideration is 2018-081. This involves the property at 2101 Old Hickory Boulevard in the southernmost portion of Davidson County before you fall off into Williamson County. This involves the Forest Hills Baptist Church, the owner of the property located at that address. The request is for a special exception for an expansion of the church at that location. The special exception, of course, is required under the zoning code 17.16.150 and following, based upon the fact that it is a residentially zoned district. Thomas Dodd is a representative for the project and will address the board. Clearing up one thing before the first question gets asked, this is just about the special exception. Building permit is likely to tag sidewalks at a later date. They may have to come back for that at a later date, and if so, we'll take it up at that later date. As for today, just the special exception question for the church. Is there anyone here in opposition to case number 81? Seeing none, the appellant will have 5 minutes, if those 5 minutes are needed, to make the desired presentation to the board.
Good morning. I'm Thomas Dodd with HMK Architects, representing Forest Hills Baptist Church, 2101 Old Hickory Boulevard. We have met with our neighbors, with the Homeowners Association, to show them the property, the expansion that we're doing. And we have also met with our largest neighbor, who's not part of the homeowners association, and met with our councilwoman, and at present do not have any issues against the facility.
Okay. Any questions for the applicant about this special? Do you had a public hearing, a meeting with the neighbors?
Yes, we met with the homeowners association and with Ms. Fox, our largest neighbor.
But you sent out letters and
Yes,
saying, inviting,
that's
and so
correct.
what happened there, and any interesting insight after that meeting?
We didn't specifically have a called meeting. We just went directly to each, to the homeowners association and those that the letters went out to discuss with them.
So you didn't have a meeting like at 7 o'clock on a Thursday?
Correct. Back in 2009, we also were before this board when we expanded in 2009. We sent that letter out and we had a meeting, and no one showed to the meeting.
But you didn't have a really kind of meeting this time. You met with people, but you didn't say, show up here at a certain time and we're going to talk about this, what we want to do.
Correct. We went to them because they didn't come to us last time.
John Michael, I went to law school, you did too, and I see you over there researching this. Our special exception requirements require a meeting. Is what was described fulfill that, even if letters went out?
Covered by the Board of Zoning Appeals Rules of Procedure, which, as you know, the board itself is the arbiter of whether or not the rule has been followed. The rule in question here, I believe, is Rule number 9. Forgive me for trying to get all the subsections correctly identified, Mr. Chairman. Rule 9D. Part 2, Part D. It reads as follows. In the interest of having informed stakeholders in special exception cases, such as this one, it's required that an appellant make contact with a district council person and neighborhoods within 600 feet of the subject property from a mailing list provided by the board staff. Information to be furnished by the appellant shall include a contact person and a reasonable representative of their proposal, and hold a meeting at a geographically convenient place, date, and time. Applicants shall document to the board this requirement has been met. Failure to comply shall result in deferral of their case. Mr. Chairman, they have obviously reached out to people within 600 feet as required. They have, in fact, furnished a contact person, a reasonable representation for the proposal. They've documented to the board that they have done so. The question for the board would be whether or not you determined that, in fact, a meeting had been held at a geographically convenient place, date, and time for those people notified within the 600 feet of the subject property. Forgive an indirect answer, but it is the board's to determine.
Okay, board members, was that a meeting? And if it's not, what that means is they've got to send out letters, invite people, invite the council person to have a meeting. So was that a meeting?
Could I hear again exactly what transpired?
We contacted, well, we sent the letters out, and we contacted the homeowners association, that's the neighborhood directly to the east or west of us, and met with them at their homeowners association. We've met separately with Ms. Fox. She's the major person on our property. We met with our councilwoman at our property, and she specifically talked with the Forest Hills building that's across the corner from us.
So when you sent out that letter, did it say meet here at 7 o'clock or some day, and if you have any questions, we'll be here to answer all the questions about this?
No, we just sent out a letter stating this meeting. And
This meeting today?
This meeting today.
Okay. I don't think that is our requirements for having meetings for special exceptions. Board members, what do you think?
Well, he didn't meet, he didn't meet with the HOA.
No,
and
but
I know
our
that's.
laws very specifically say you are to have a meeting, and it's supposed to be geographically close, so it goes a little bit specifically about that. You know, it would have been if they sent out the letter and said, we're meeting with the HOA Association at this time and place, and you're welcome to come and hear more about it, that probably would have satisfied our requirements because it was an open meeting that anyone can come to. And the reason that we have this rule is if someone wants a special exception, which could be a significant change, we want people to have access to the people that are requesting it and to ask questions prior to our meeting, not today. This is not the time for someone to come in and find out about it or discuss it with you. So I don't think, let me ask our lawyer, is this a meeting, was that a meeting, basically what he said, based on our rules?
I'm going to have to reiterate what Mr. Michael said, which that I think is ultimately y'all's decision. I mean, the rule says there has to be a meeting at a geographically convenient place, date, and time, but I think it's up to the board to determine if that meets those specific, was it a meeting at a geographically convenient place, date, and time?
It was, but the problem is people weren't invited to it. They just met with some key shareholders.
Well, I guess if the homeowners association,
Who else would have been invited?
if the homeowners association,
People
did the homeowners
600 feet.
association announce that you all would be part of their agenda?
Correct. The homeowners association did announce to their members that they were welcome to meet with us, that they were meeting.
So the homeowners association said, we're going to talk about this, people from the church are going to talk about the project. If you want to come, come.
It was specifically said in their agenda and their notice. So here's the question. Is there anybody else within 600 feet of your property that's not in that homeowner association?
Potentially, maybe 2 people.
Okay, yeah.
But didn't you say you met with one of them?
Correct. We met with Ms. Fox, who's
not.
directly behind us.
What about the people across the street from?
That's Williamson County, but technically they would get notices too, right?
That's Williamson County.
Is that Williamson County over there? Do we send out notices to our neighboring county for special exceptions? It's within 600 feet, you'd have.
The list that we received did not have any Williamson
Oh,
County
that's right. We
addresses.
wouldn't have the addresses for that, so I guess normally you wouldn't. Okay. We've heard from 2 lawyers that say it's our decision. So board members, what do you think?
I think you could make a case either way, but I think the fact that they did, it was specific to the agenda of the homeowner association, and that all the letters got, all the neighbors got letters. We don't have any opposition. It is a religious organization, which means that there's the standard for denying any type of addition that they would want is so great that frankly, I'm not sure that the opposition would matter. There's nothing, so I'm not sure how that would change the outcome, but also that you could, like I said, make a case either way. I think your point is correct that they didn't follow the letter of the law, which says we're going to have a special meeting specific to this, but it sounds like that because the homeowners association publicized it and said this is why we're meeting, or part of why we're meeting, and come and talk about it, that could be constituted as a meeting, considered a meeting.
Board members, are we comfortable with proceeding in this case, or do they have to have a specially called meeting?
With what Mr. Taylor has said.
I tend to think they met face to face. I would feel a lot better if you had the letter, if you had the agenda. You've not come forward with a lot of evidence for us to have in the record and to make us interpret our own rules. Do you have any of that information?
I don't physically have it here, but I do have emails that the 600 feet only goes out to half of the homeowners association. And so we wanted to make sure the whole homeowners association received it. And so it was emailed out to the whole homeowners association.
Do you have a copy of that email, like on your phone or anything?
I do not.
Counselor?
I think to me, I think we should have better evidence in front of us, although I tend to think that what he did was sufficient to be meetings. And it seems to me that if he wants to submit that information and we can determine if the meeting was held, I would otherwise find that it sounds like they've met the requirements for a special exception. But I would like to have the record show that there
absent-
was sufficient notice.
Okay.
That would be my thought.
Is it possible to just move this one toward the end of the meeting and give, I mean, we're going to be here at least an hour. If you
Works
have a
for me.
chance to get a copy of that email, and then we can, just some evidence that the homeowners association did declare that a meeting.
And it was
That way you can get
specifically a line item in the invitation that this meeting, we're going to discuss this new project.
I believe that's correct, yes.
Okay.
Yeah, so if you can produce that before the meeting's over, then I think we can.
Yeah, we're
hear it.
going to
Otherwise,
come
we'll have
back to this
defer it.
case after that, okay? So thank you. John Michael.
Tabling that item to later in the agenda, we'll move on to case number 2018-082. Another short-term rental case, Shaylee O'Neill, the appellant and owner of the property at 836 Glen Avenue, has brought this item a appeal based upon denial of a short-term rental permit. This is in Council District Number 17. You've already heard from the district council member with regard to this property. Zoning map here shows the property along Glen, just off the 9th Avenue South corridor. Aerial photograph here shows the subject property, and from the tax assessor's website, the face of the property. Is there anyone here in opposition to case number 82? There is. As a result, the appellants will have 10 minutes to make the desired presentation, after which time you'll hear from any of those from the opposition who wish to speak. A reminder for the appellants, if you want to save some portion of your time for rebuttal, do so out of this originally allocated 10 minutes. With that, we'll invite the appellants to come introduce themselves by name and address and make the desired presentation.
Oh, do we hear from,
Mr. Osborne, or
Yes,
Mr.
I'll allow you to hear from zoning staff first. All apologies.
Mac? Tell us about this case, non-permitting violations, and any other information that we need.
This was a hotline tip that came in, and it was concerning the type of permit. They were questioning whether or not it was actually an owner-occupied permit. There's been a previous case on this, and it was proven that this is an owner-occupied.
I'm sorry, you said it is proven owner-occupied or not?
Was proven owner-occupied.
Okay, yeah, because one of the letters said that they didn't think it was, I just didn't know.
Yes, it was, the violation was resolved, so
Okay.
that means that
Okay.
they did approve it. The permit was initially issued, this is an expired permit. The permit was initially issued in September 16 of 16 and expired, of course, 1 year later. There were only exterior pictures of the property, so we made the match on Google, but the notification of violation was then sent on February the 2nd. The ad remained up on February the 9th, so the stop work order was posted and photos were taken. Host says that the advertisement was removed on the 13th. Probably was removed before then because the appeal was filed on the 12th. The reinspection date was slated for the 21st of February. The ad remained down. It has since remained down, not been reposted, and there have been no documented stays. After the permit expired, there were a total of 4 documented stays, the last of which occurred in November.
Any questions for Mac? Okay, thank you. We're going to hear from the applicant. To remind board members, this is one of the cases that Councilman Sledge spoke out against, that he has gotten 16 emails about this case, which he described as the most emails he'd ever gotten about any single short-term rental, and he is in a very popular district along with Councilman Allen, O'Connell, and Withers as far as just probably the most short-term rentals in the 35 districts. So please proceed.
Great, thank you for your time. Ryan O'Neill and my wife Shaylee, we live at 836 Glen Avenue. Board members, thank you for your time. Obviously, this is going to create some lively discussion considering the amount of emails that you guys received. My wife and I purchased our 5-bedroom house in the fall of 2015. We're a family of 2 and wanted to soon start a family together, but in the meantime, needed to supplement our income by doing short-term rentals. In the fall of 2016, 1 year after we purchased the house, we began renting our house on Airbnb as a owner-occupied listing. This is our full-time house. We have lived there since 2015. We had received a permit in September, as Mac referenced. Even though our house is a 5-bedroom house, we do not allow access to that 5th bedroom in compliance with the 4-bedroom maximum. On September the 16th, 2017, 1 year later, our short-term permit expired without our knowledge. During that time period, we received a total of 3 complaints for our listing, only one of which was noise-related. That was in October of 2016, 1 month after we started renting out our house on Airbnb. We made some changes to how we checked in guests. As you may know, Airbnb has an anti-discrimination policy referred to as Instant Book, where a guest can book your house as long as they fall within the criteria, and you can't decide whether or not you want to host them. I think there were some discrimination issues being resolved there. So we turned on our Instant Book, and we started to individually check our guests in October. Since then, we've not had a noise complaint. As in February of 2018, on Friday, February the 9th, we came home to a stop work order notice. And on the next business day, Monday, February the 12th, my wife Shaylee went to the codes office and was denied a short-term rental permit. We took down our listing that very week and have not listed out our house since and have canceled all associated reservations with that house. During that time period, we canceled the reservations. Was devastating to us in terms of short-term income, but we found that it would perhaps find good favor with the board in taking the recommended steps in removing the listing and canceling the reservations. We've had a total of 6 groups stay at our house since our permit lapsed. The reasoning for that is similar to the one previously. We just simply did not know. A total of 13 nights during that time period. During this time, we operated with an expired short-term rental permit, and we were not in compliance with the board. However, further proof to support the claim that we did not realize our permit had expired was that we continued to operate our listing as normal, which included paying our hotel and occupancy tax for all 6 of those rentals after September the 16th, 2017. In the past 18 months, we have paid close to $5,000 in hotel and occupancy tax and wish to continue to be able to pay that tax with the reinstatement of our short-term rental permit. In closing, I would ask that the board consider this merely as a lack of communication between spouses rather than a couple who are trying to circumvent the process of owner-occupied short-term rental permits. I understand that most appellants who come before you never go through the trouble of applying for a short-term rental permit, but we are not in that group. We've learned a valuable lesson and hope that the board decides to grant our request to restore our short-term rental permit or at least allow us to apply again soon. And just in closing, I just wanted to reference just to confirm the fact that those 3 complaints, one of which was noise-related. We've had multiple people complain that we do not live here, and I don't know if I can pass this around. Is that a thing that I can pass this around? This was shortly after our short-term rental permit was granted. We had people calling to say that we did not live there. My general feeling is that our neighborhood is very anti-Airbnb in general. On our street, there's only one other Airbnb that's short-term rental permit, and that's right next door to me, 834 Glen Avenue. We take turns kind of keeping watch over the house during rental periods. And the fact that a red sign went up in our yard and then we all of a sudden had 16 complaints of noise to me represents the general anti-Airbnb, and I don't think this is a discussion on whether or not that's legal. It's just a matter of have we done our best to comply with the rules and regulations.
16 complaints or 16 emails is a lot. And Councilman Sledge here, who, as I said, represents a district that's probably either first, second, third, or fourth in total Airbnbs in this whole city, said to us he has never gotten so many emails about one particular property.
I believe several of those emails were related to the fact that we were not owner-occupied, which Mac claimed that was.
But I'm reading some emails that talk about noise and talk about the number of people. So how many people do you normally rent to when you do have Airbnb?
12 max. 4 bedrooms times 2 plus 4 is the understanding.
So we have a letter from neighbors. One person says there was a weekend party of 18 to 20 people. Then another one says they allow multiple people up to 20. And then another one says every weekend 15 to 17 guests would pile into their home and party through all hours of the day and night.
We rent out our house on average of 4 nights a weekend. So the every weekend email, excuse me, I'm sorry, I saw that face. 4 nights per month is our average rental. So every weekend is just not true. I own 4 dental offices. We have a total of 30 employees. We do most of our office outings at our house. I would argue that there's no way to show whether or not we were an Airbnb group or our office staff. We tend to be a little rowdy. It's a big group, but I would argue that that's.
So your office staff, you entertain your office staff monthly at your house?
Oh, no, not monthly, but we do have weekend parties, I think was the reference to.
How
the
often?
email. Usually holidays, so Christmas, birthdays, anniversaries.
Okay.
May I ask a question?
Yes, ma'am.
You did say that you limit to 4 bedrooms because of that restriction. Does that mean you stay in the 5th bedroom, or are you not on site when you're renting?
Yes, ma'am. I just learned with Councilperson Sledge that we are required to stay on site. We were not aware of that. We plan on doing that from now on, having that 5th bedroom. But no, ma'am, we have not been staying there during those average of 4 nights a month.
So if we're going to hear some from opposition, but you have, how are you to police the people that you rent the house to if you've admitted to us the people that even work for you are just wild and you let that go on?
Well, now that I know that I can stay at the house, I plan on staying there and policing it on site.
I'm talking about your employees. You admit you have parties in your house and your employees come over, and your words that they are wild.
My employees are wild. The parties that we tend to throw, try not to be.
Try not to be. That is not much solace for your neighbors when your employees are there or these people renting your house.
Right. But I think, my understanding was that this meeting was related to the short-term rental permit, and I would.
That's what I'm talking about, your management of the short-term rental, and I'm trying to figure out, how good of steward of you of this permit, and that what kind of oversight you have. We have all these letters of complaints about parties and number of people, and if you're not there in the past, how do you know what goes on, and how do you enforce the rules and the noise ordinance? And basically, if you are used to having parties at your house with people that work for you, which you have some control over, and you describe them as wild when they're at your house.
Not while they're at to clarify, I said that they are rowdy, but they're not rowdy at my house. That was probably a misstatement.
So they're rowdy at work?
They're rowdy in general. They're just a fun bunch.
So I'm supposed to believe that, when they come to your house, they're just angels?
I'm not sure what you want to believe. I try to manage that and keep the noise down. We don't play loud music, but there's 30 people in one backyard. I think just we're not throwing a party and taking shots and playing beer pong. It's just 30 people in one backyard. So, that's going to generate noise, especially when there is a close proximity house right next to you.
Okay. Question?
Were there any positive letters written?
Not that we have, and as I said, the council person said he got 16 letters about this one property.
Was there any positive letters that were written?
We have
emails?
board members, we have 4 letters in opposition in our packet. There's no positive letters that we have. Well, Councilman Sledge says he has 1. So 1 positive letter, email, 16 opposed. Questions for the applicant? Okay, well, let's hear from the opposition. You'll have 5 minutes, 33 seconds for rebuttal. And the opposition, please come forward, state your name and address for the record, and why you are in opposition to this case.
My name is Dale Truitt. I'm here representing myself as well as Dr. Carol Jonron. We are both retired. We live right next door. Our bedroom is as far away as that post right there from their house. So I don't want to belabor all of these complaints that we've just heard about, but I want to thank Councilman for attending today, and we would like to add our name to the 16, make it 17.
So what have you observed when you live right next door?
I've observed noise late at night. I've called the police twice in the last year or so.
When you say noise, is it loud music or is it just a bunch of people talking? What is it?
I would say more than talking and loud music, all of that.
Is it outside or inside?
Mainly outside. They have a carport with no walls that they've converted into a bar.
How long have you lived there?
We've lived there 8 years.
Okay. So how often does this happen?
Too often.
What is that? How many times a month do you have to complain or think, why am I living next to this?
I'm not so sure. It's the complaining part is that Friday when you anticipate very anxiously who's going to show up.
Why would you anxiously anticipate who's going to show up?
Well, because of the record that we've experienced in the past.
How many people do you think show up, and what kind of numbers would you put as far as the number of guests that you've seen?
Hi, I'm Carol Gendron, and I live at 838. And I would say that it's the person who said 17 to 20 was quite accurate. It is always a large group because it is a large house.
It's more than a dozen?
Yes.
Well, how do you know that?
Well, because I have gone out on the porch. They have been in the front yard playing games, playing horseshoes, making a lot of noise late at night. So we have a low hedge that you can kind of see over. And it's been, easily over 15 on a regular basis because it is a large, beautiful home.
Question for the opposition? Anything else to add?
No, and I mean, we want to be good neighbors. And they, when they're there, are good neighbors, but they have not been there. And, we could not contact them to let them know what was going on. But certainly they themselves, I want to say, are good neighbors.
Okay, thank you. We're going to hear from the applicant again. Please come forward, rebuttal time. Respond to what you just heard.
Is there a picture of front of our house? Can we put that back up? So the hedges are between 6 and 8 feet. So in terms of verifying how many people are in our front yard by peeking over the hedges, you can feel free to drive by afterwards. It's not visible. The reason we have those hedges is for privacy to reduce the noise. The carport is not a bar. It is a carport where we park. We no longer allow our Airbnb guests access to that. If you were to drive by, you would see a bunch of storage, canoes, et cetera, in that area. So to those 2 points, that would be.
They no longer, when did you stop allowing access to that?
When it got cold last year.
So before that, they had access?
Yes, sir.
And now that it's warm again, do they have access?
We're not renting out our house right now.
Will they have access in the future?
My plan is to not have access, no, and I would be willing to commit that to Carol and Dale.
Okay. Any other things to respond to what they said?
Yes. I just wanted to say that in terms of not being able to contact us, they live right next door to us. I've recently given Dale my cell phone number. When Colby told me that, our councilperson Sledge told me that we had had the number of complaints that we did, I instantly gave Dale my cell phone number. And honestly, I respect and understand what they are saying. I just don't think that they can with accuracy say there are 20 people in our house unless they are either on our back porch with them. And again, we have an 8-foot back fence. I don't know how they would ever see them. We just have no knowledge of more than 12 people being in our house, with the exception of office get-togethers. And I do apologize for the rowdy comment. That was my point I was trying to make, is the only time there are more than 12 people at our house is when there are 25 or 30 for office get-togethers. It is not a hoot and hollering party.
Okay. Any questions for the applicant? Okay, anything else to add?
I would like to ask that they would consider that November the 10th was our last violation. We've not rented it out since and have no current listings. And I think my wife might want to say something. We don't plan on doing this long term to Dale and Carol. I mean, this is not something you're going to have to live with forever. This is just 2 recently married couples wanting to make a little extra income before we start to have kids. And then when we start to have kids, then it's no more. I do want to point out that across the street from us, there are 2 houses that have a total of 4 apartments in each, so 8 total apartments. In terms of how much foot traffic Airbnb generates, I would argue having 4 nights a month of 12 people is much better than having 100% of the time 10+ people at our house. And so I think that we are good stewards of how often we do it. My wife will not let us rent it out for more than 2 weekends a month. It's not fun for us, but it is a necessary obligation that we have financially to make ends meet. I think she wants to say something.
Yes. Shaylee O'Neill, Ryan's wife. And I just wanted to say that also to Del and Carol that we don't want our house to be a party house. Like, I care a lot about what it looks like on the inside, and I've taken care of it, and we put a lot of time and effort into it. And so I don't want rowdy people in our house. And so, like I said, we've never gotten any complaints to us. We would have made a lot more steps towards stopping anything like that had we known. But the minute that we got these emails or notifications of them, we started brainstorming on how we can make that stop, on how we could maybe set up cameras in the back and just tell them they're not allowed to go out the back deck, and that there's no partying or music outside, and that just setting up a lot stricter boundaries. We're more than willing to set those up because we don't want our neighbors to be uncomfortable either. So just, yeah.
And it would have been easy to make those changes had we known there was an issue, instead of waiting until there's a zoning appeal sign and now there's 17 people who have an issue. So I would say some type of transparency between our neighbors, that if you're watching or if you have an issue, just come knock on our door. We live there.
Okay, thanks. Does Councilman Sledge have anything else to add? You've heard both sides here.
Thank you, Chair, and thank you, Board. Just a quick clarification. I think at the beginning, when I was going through this, I was referring to, well, I was thinking about that you had taken this up before. You've not taken this up before. I was referring to a different case, which you probably know by now. So I want to make sure I clarified that. I'm just going to speak to, and I spoke with the applicant out in the hall and spoke to some of the issues. And this is the biggest thing for me. I think the issue is that despite, I mean, we could go through a kind of he said, she said thing, but the truth is that the applicant doesn't know how many people are at that house because they haven't been there. And so I have to, as a council member, depend on the folks who are there, like the neighbors who spoke, to get an idea of what the situation is and what's going on. And I will say, just in my experience, and I think probably y'all's experience as well, a lot of times neighbors don't talk to each other about this because it's conflict, right? It is, you are approaching your neighbor and telling them that they are doing something wrong. And for some people that comes easily, and for others it does not. And I've received messages from people who've said, look, we don't want to be seen as jerks, but this is a real problem, that this is a real issue. And that's part of the messages that I've received. I really think when it comes to an issue like this, when you have so many people who are saying, we have a problem with this property, and despite the fact that I think the applicants are good people, and I think that they probably have made some mistakes that were not malicious, I'll put it that way, but still made some mistakes. And I think this board obviously has a jurisdiction about whether they feel like those mistakes rise to the level of that there needs to be this action taken or maintained. I would say in this case, unfortunately, I think the action needs to be upheld.
So based on that, Councilman Sledge, what are you recommending that we do here?
Well, you know, it's funny, a lot of the things that you've been dealing with as far as time periods and stuff are part of legislation that actually I helped write. So I don't take credit, I partly apologize as well. So part of that is whether you get up to a year of sort of grace period, whether you get really thumped if you've had court action taken against you. I'm not sure that this is a grace period issue. I'm not sure that this is a up to a year issue. I think that this board should probably uphold the actions that the codes department has taken. And I think that whatever the waiting period or ban or whatever you want to call it that you're able to impose, I think you should impose.
Okay. Any questions for Councilman Sledge? Thank you for being here.
Thank you.
We're going to close the public hearing. Now this falls into the 0 to 12 month. As Councilman Sledge said, it's not a year, it's not nothing. This is what we get to do.
I thought he just said it was a year.
It was a year?
I mean, yeah, I mean, to me, you know, not just because I think it's been tough to sort these into categories when you have basically 12 ticks. I'm mainly trying to think of it in terms of which third of that cycle is it? Is it 0 to 4, 4 to 8, 8 to 12? And with, 12 being that. And so, certainly Councilman Sledge thinks it's 12, and it's a tough one. I mean, on the surface, the story looks similar and fine, but at the same time, we just never have the level of complaints as we've seen, and even from those neighborhoods that have very, very strong feelings about Airbnb, and they seem to be more specific complaints instead of generic. I mean, often when you have a case that has an awful lot of complaints, they're just, well, I just don't like Airbnb. And I respect that opinion, but citizens have a right to this, and so that's discounted a little bit in terms of how we look at it. But when they have specific complaints to say, no, this is a problem with this house, then I think that makes it different. So,
For discussion, what do we think?
How to say it, but it's, we're not here really hearing a three-strike case. We're really hearing whether or not they operated prior to obtaining the legally required permit. And I don't have my STRP cheat sheet in front of me, but I guess we can take into consideration the noise complaints. I mean, that's a factor we can look at when we are.
And if you believe the letters and the opposition here present, that more than 12 people.
Well,
I guess I'm asking, are those all things that we can take into consideration?
Let's ask our lawyer.
I think that you can. There's a specific list of things that can be considered, such as the testimony of the short-term rental operator, the testimony of neighbors, evidence that the operator was informed of the requirement and disregarded it. So there are, and some others, there are factors that you can consider, one of which, as I said, is the testimony of the neighbors, but it also says evidence to be evaluated and making this decision may include but is not limited to. So I think that if you find that the noise or whatever other complaints are pertinent to the determination of how long the ban, for lack of a better word, should be in effect. Excuse me. I think, yes, you can consider that.
Okay, thanks.
Okay, so we have a councilman talking. We have emails in opposition. As the councilperson said, he got one letter in support, and we didn't have any to this board in support. We had 4 in opposition.
Well, I agree with what my colleague says. She makes a good point that it's an item A appeal. We're not talking about complaints that we actually received, although we did have evidence that the police were called 2 times by the neighbors on this specific property. And the opposition is specific. I mean, I tend to think it's at least a 9-month case if we find that zoning administrator did not err, and give them the opportunity to reapply for the time period that they were not in compliance. I mean, that.
This, we heard from to me, what it comes down to, as I said, there are 4 districts basically in Nashville that have probably 80% of the short-term rentals. Councilman Sledge, Councilman Allen, Councilman O'Connell, and Councilman Withers. And so the fact that Councilman Sledge comes to us and says, I've never gotten as many emails complaining about a short-term rental, which probably, has it's also not the number, it's the frequency or velocity, if you will. That's if you're near downtown and you have a good house, you could probably rent it at least every weekend and probably many nights of the week. So the fact that this is in front of us and he's here telling us that this is kind of a, high watermark case for him, I think this is a year case.
I won't disagree. I guess what I would say to that is the complaints have not been ongoing. They all came in once the sign went up in the yard. And so I would feel differently had the complaints been month to month to month. And we do have compelling letters from neighbors. One family moved, they say, as a result of the conduct of the property.
And I agree with both of you all. We get generic, I don't like short-term rental letters all the time. But this was very specific to why this particular house is been, not good for some of these neighbors.
So my thought was, I don't disagree with Councilman Sledge, and I appreciate him being here all day and taking a difficult stance.
And if Councilman Allen were here, she would say, look, the law says it's a year. You all have the ability to drop that, but basically it says it's a year. That's where you're starting from. That's what she has said many times. Well, I'll make a motion that the zoning administrator did not err and that they not be allowed to apply for a permit for a year. Now, I do not know the date. Does anyone have a better date? The applicant said a certain date of November 10th.
They applied for they did not reapply until February of this year. But he's alleging the last time they rented or the last violation, according to the applicant, was November of 17.
So no,
Which, if you did it from November, would be an effective additional 9 months.
So what do we think about the date, board members?
Year from November, because that is the last time that they rented. That's what I wrote down, it was November.
But given that this is kind of a case where they didn't have a permit, does that change your mind?
You could ask Bob if.
Bob.
Or Mac, whoever was up here, what the last
Mac,
documented.
what's the last kind of interaction you had with
Last documented rental.
the documented rental with this, or documented posting and rental? What date was that?
The last, the host confirms that it was down February the 13th. Possibly was down on the 12th. They don't check every day. But they filed for their appeal on the 12th, so that was a Monday.
So is it safe to say that they had postings like a week before February 12th?
There was no documented stays. Give me just a moment on that. The last documented stay was in November, and there were a total of 4 documented stays during the time between the expiration of the permit and then the end of the taking down of the ad.
Okay. So my motion is that the zoning administrator did not err and that they be not allowed to apply for a permit for a full year starting at the date December 1st, 2017. So the year starts then. That's the motion. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes. John Michael.
Next case to be presented to the board is 2018-083. Dwayne Cuthbertson is the appellant on behalf of Magnus Devco II, the owner of the property located at 1400 Ordway Place in Council District Number 6. You previously heard from the district council member with regard to this sidewalk variance case. The aerial photograph here shows the subject property. In this particular photograph, the undeveloped lot at the intersection. The site plan submitted demonstrates the proposed layout of the construction, which is already underway at that location there at the intersection of North 14th Street and Ordway. From our recent site visit, and this is one of the cases, Mr. Chairman, where I think the site visit photos may tell the story as capably as any other documents we have in our file. The view up and down, let's see, it's 14th here on the upper left-hand corner. You can see the existing planter strip and sidewalk in good condition, not as narrow, not as wide as the current sidewalk standards would require. And in the lower right-hand corner, the view down Ordway, again, without a planter strip, but wider than the one on 14th, probably not the same condition as would be required under the current 2016-493 sidewalk ordinance would require. Again, you've already heard from the district council member on this matter. You have in your packet the recommendation from the planning department, which includes the recommendations that have been considered by the historic commission as well, given that this is in an overlay district. The appellant is present, prepared to make the presentation of the board. Is there anyone here wishing to speak in opposition to case number 83? There is. As a result, there will be 10 minutes made available to the appellant and to all the opponents as well.
Okay.
Please come introduce yourself by name and address.
Chairman, members of the board, Dwayne Cuthbertson, 438 Wingrove Street, Nashville, Tennessee, representing Magnus Group. They're constructing a new single-family dwelling at 1400 Ordway Place, and That construction has triggered the sidewalk requirement, and we are asking for a variance of the sidewalk requirement in its entirety. We would like to keep the existing sidewalks and not pay the fee in lieu. As Mr. Michael showed you on the screen, the existing sidewalks on Ordway and 14th are consistent along both block faces, all the way along 14th. The sidewalk in front of our, I'm sorry, I meant the sidewalk on Ordway in front of our house all along, lines up with the sidewalk all along Ordway on this block face. And the one on 14th aligns generally with the sidewalks up and down 14th for several blocks. These sidewalks, as evidenced by the letter of recommendation from the Historic Commission, are part of this historic fabric. It's a historic neighborhood, one that's been memorialized by the adoption of the Neighborhood Conservation Overlay. The requirement would have us rip out the existing sidewalks and push them further into our lot by 4 or 5 feet on both frontages. The new sidewalk on Ordway would actually be narrower than the existing sidewalk. The existing sidewalk's about 6 feet. Ours would be pushed in and actually narrower on Ordway. On 14th, the new sidewalk would, with the MCSP would require a much wider sidewalk in the grass strip, and that sidewalk would actually be pushed up right against this house. We're asking for the variance so that we don't have to push these sidewalks out of alignment with the historic character and the historic sidewalks in this neighborhood. Again, historic neighborhood, most of the houses on Ordway, most of the houses on 14th are contributing. It's very unlikely that any of them are going to experience additions. They're certainly not going to be torn down, such that they would require sidewalks in the future that would eventually align with what we would be required to do today. On the other side of the requirement, the fee in lieu, this is a corner lot. There's 200 feet of frontage. The fee in lieu would have us pay over $35,000 for a single-family dwelling to the fund. And having to pay that fee in lieu really puts the builder in a unique position of having to decide whether he goes forward and just builds a sidewalk, which would, in his estimation, would be somewhere between $20,000 and $15,000 less than the fee in lieu, or keep the sidewalks where they are, consistent with the historic character, and go ahead and just fork up the $35,000. We've got support from several immediate neighbors. I know we submitted some by email, but I'll resubmit these for the record. 5 letters from immediate neighbors asking that we not be required to construct the sidewalks and not be required to be put in that position of having to choose whether we pay the fee in lieu or construct them. It's supported by the planning department staff that their recommendations that we don't build and we don't have to pay. That was somewhat supported by Historic Zoning Commission staff, again and again by some of these immediate neighbors. So we're just before you asking for this variance in its entirety, and with that, I'll rest and answer any questions.
If you were to build a sidewalk as required by the new ordinance, would that also require an easement? And would it go into your property, or?
Absolutely. We'd have to dedicate right-of-way on both Ordway and 14th, and we're not opposed to dedicating the right-of-way for future sidewalk construction. If Metro were to come in and say, we want to build 14th from Woodland to Eastland per the MCSP, they would have our right-of-way so that they wouldn't have to negotiate with future users. And the same with Ordway. If Councilmember Withers is able to organize funds to build a better sidewalk along the entire block face, we'd give up that right-of-way so that he has that for future use.
Okay.
He was asking for the Ordway sidewalk to pay into the in lieu fee, and it looks like it's a 50-foot wide lot, so at 178 lineal feet, that would be about $8,900 to pay into the in lieu. Is that your understanding too?
If that was imposed, yeah, that's my
Sounds about right.
understanding.
Okay.
Any questions of the applicant before we hear from the opposition?
Is it your understanding that planning also recommends no in lieu fee? Their recommendation that I have doesn't specifically say that. So
I'll have to check. I have to defer to Mr. Michael. I glanced at it and I thought it said
Okay.
the recommendation was
They
not to build.
do approve your request for the sidewalk variance with certain conditions.
I've never seen them say approval where they wanted a fee where the fee wasn't specifically said, you know. Like all the rest say, you know, approve the variance with the condition they pay in the fee, you know, so I mean, it's
The
common.
absence of it.
Take that.
Mr. Chairman,
I would take it as no fee.
if I may confirm that, the word approval in that simple manner from planning is indicative of the approval of the appeal as filed, which in this case is no build, no pay. And that's been specifically contemplated there.
And we have 4 letters here saying no bill, no pay.
Okay, any other questions before we hear from the opposition? Okay, let's hear from the opposition. Please come forward, state your name and address and why you're opposed to this.
Ron Gomez. I live at 1309 Gartland, which is just the next block over. Could we go back to the other site or the other photo? Yeah, if you could see to the left of the property, that's a school there. That's a school playground. And there's a 4-way intersection there. I see people run that stop all day long. There's no crossing guard, unfortunately, with the school. I'm having rounds with the school. That's another issue altogether. However, if they're going to build that house, which is already under construction, they started construction about 2 months ago, and they're already on the 2nd floor, you can't see that intersection. And the street going this way, it's heading east on Ordway, that street is so narrow, you can't park on one side of the street on the north side. You can only park on the south side. I've got my own plumbing business. I drive just a standard 8-cylinder truck. It's not a huge truck. I can't pass another vehicle on that street. You have to like move over to let another car go. You can't get 2 cars. You can probably get 2 small cars to pass each other, but with a parked car on the street, I can't fit through. So I always avoid that section of the street. But if they're going to build that close to the street, you cannot see that intersection until you're on it. So if there's cars stopped and, stopping for the 4-way, that's not an issue. But if you have no one there, people run through it all the time. There used to be Metro cops on Ordway just waiting for people to run through that in the morning. My concern, I would love to see that sidewalk pushed back to give you more of a sight line for cars coming in, especially in the morning, because there's no crossing guard. But it happens all day long when people are traveling through. And my other concern was, how are they able to, in other words, shouldn't they have looked into what it would cost or what's involved with the grass strip and the sidewalk before they decide to actually start construction? The house immediately next door to that vacant lot, I've done work for the previous 3 owners, and my understanding was that lot was part of that house, and it was. The last person that sold divided the lot. So that lot, I mean, yeah, it's 50 feet, but it's a narrow 50 feet, and you can even see there's a garage in that bottom left corner, which was part of the house. They had to surrender that garage when they sold this new piece of land. So it's kind of a mess going on. The current owner asked me about something running him a new water main, which is actually on the new people's property. The water main for the house next door that's existing and the gas line are on this property. So I don't know what they're going to do. It's just a narrow property. They shouldn't be building anything on there anyways, but the fact that they are, it's going to look like a spaghetti box, and you can't see that intersection.
Questions for the opposition? Thank you. We're going to hear from the applicant rebuttal, so please respond to what you just heard.
With regard to the construction of the house, the house was approved by the Historic Zoning Commission several months ago with its current design and then also its position on the lots. So, you know, where the house is positioned on this property is not really up for discussion with this BZA today. In terms of increasing the sightlines, if the sidewalks are enforced, if we have to build the sidewalks, the curb line's not changing. So the curbs on 14th and on Ordway will stay where they are. It's the new standard would be measured from the existing back of curb. And so we just have to increase the grass strips on both street frontages and then build a sidewalk per the standard from there. Parallel parking would still be allowed where it's allowed today on Ordway, and of course there's no parallel parking allowed on 14th. So I don't believe that enforcing the sidewalk requirement today would do anything to improve sightlines, unfortunately.
Okay, question of the applicant? Okay, thanks. We're going to close the public hearing. Discussion. So we have this recommendation from planning.
Yeah, I mean, I appreciate the opposition's coming and expressing his concern for safety, and I get what he was saying. I'm trying to figure out how to relate it back to the sidewalk exactly. And I do appreciate him waiting and talking about that. I know that is also something that the Planning Commission and the staff and the Historic Commission and other people consider too. And it's just so extraordinarily rare to have the Planning Department recommend an approval without a fee. There are many times when we decide, that there shouldn't be a fee when they recommend a fee. And a lot of times when we ask for a fee too. But it's just so unusual in this case, and I think that's probably why it was on the consent agenda. I agree with the Planning Department and think it should pass.
Well, I'm a little different, and I don't think it's unreasonable that Councilman Withers would ask for a payment to the in lieu fee. And I think it was reasonable that he asked for only one frontage. He didn't ask for both frontages. And it's a new home, and applicants that are building new homes that come to our board, or not even come to our board, some don't come to our board, they just build the sidewalk. So I don't think that was unreasonable, and I'll support Councilman Withers' recommendation.
I mean, I just, and the only reason I agree with Historic and with Planning is, you have it's a 7-foot sidewalk. It's not a small sidewalk on Ordway. So, I'm happy to see where it goes, but I'm also comfortable making a motion that we approve the variance request.
Okay.
And I would second that.
Motion's been made and properly seconded. Any more discussion? Seeing none. All those in favor signify by saying aye. Aye. Opposed? Passes 4-1. John Michael.
Okay. Right here.
Mr. Chairman, the next case is 2018-084. Mr. Cuthbertson again is the appellant on behalf of the same property owner, Magnus Devco, in this case 16, the owner of the property located at 1009 Caldwell Avenue. This is in Council District number 17. You've already heard from the district council member with regard to this request. Also, a request for a variance from the sidewalk requirements in this, the R8 zoning district. The property here shown in this R8 district on Caldwell near the intersection with 10th Avenue South. The aerial view shows you the construction in place. The site plan submitted shows the proposed development, proposing the absence of the sidewalk, of course. From my recent site visit, the photography, especially the face of the property in the right-hand corner from the dead middle of the street, safety notwithstanding for the zoning staff member, does in fact show the slope of the lot. And then the views up and down Caldwell, again, give an indication of the topography of that lot and the surrounding properties as well. Is there opposition present for case number 84? Seeing none, the appellant will have 5 minutes to make the desired presentation to the board. Mr. Caldwell, or Cuthbertson, sorry.
Okay.
Mr. Chairman, members of the board, again, Dwayne Cuthbertson, 438 Wingrove Street, Nashville, Tennessee. To some degree, this is a similar request, less the or minus the historic district and planning recommendation. But clients constructing a new home at 1009 Caldwell Avenue, and triggers the sidewalk requirements. And we're asking for a variance of that sidewalk requirement in its entirety again. Application of the new construction would push our sidewalk in 4 extra feet off the existing back of curb. The sidewalk that exists in front of this property aligns with the entire block face of Caldwell. So if we were to build this sidewalk, it would be the one deviation. The guy to our left swears on everything holy that he is never, ever selling or tearing down or building. So for what that's worth, there won't be a new sidewalk there. And then if you move east of this property, you have a good number of new construction homes. So again, there won't be a new sidewalk west of this property. Paying the fee in lieu, while not $35,000, is still significant and puts the client back in that position of having to decide, well, do I save a few $1,000s and go ahead and just build the sidewalk out of alignment with everything that exists on Caldwell, or do I, eat a few thousand and go ahead and just pay? He's approached several neighbors, again, all surrounding this property, and they've asked him to not build the sidewalk, and he's explained the situation, so they've written letters of support, and I'll submit those for the record as well.
And we already have many in our packet, at least.
So some of these are probably duplicates.
Okay.
But they're supporting our request for the variance in its entirety, so that our applicant's not faced with that decision of, do I save a few $1,000s and go ahead and build the sidewalk out of alignment? That's as simple as I can make it, so with that, I'll stop and stand for questions.
Okay, questions?
The Planning Department has recommended that we approve with the condition that you pay the in lieu fee and dedicate the right-of-way, and you've said you don't want to pay the in lieu fee, so I get that piece of it. If you didn't have to pay the in lieu fee, would you be willing to dedicate the right-of-way to accommodate a future sidewalk?
Absolutely.
Any other questions? Anything else to add? Okay, thanks. We're going to close the public hearing. Discussion. We have the letters of support. I don't think there were any letters of opposition. There were many letters of support.
Well, I mean,
of immediate neighbors.
I mean, I do have trouble on some of these cases where you're asked to pay and give the right of way, which is, and these are all still relatively new, and I'm struggling a little bit with it. And it seems like it's, one or the other is fair. To have to pay to not build a sidewalk and potentially give your land for without compensation, I think I have an issue with. Maybe that's what the law requires. So I don't know. I think
Well,
one or the other.
That being said, do you have a motion? Does anyone have any suggestions?
Well, it's not a motion because I know it won't be, I'm not going to make one.
Well, speak out.
But in this case, the councilman agrees with planning to pay the in lieu and dedicate the right-of-way. And, just, again, my experience in the development world is that people are dedicating the right-of-way, and it's in the ordinance. And so that's all I'm going to say about that.
Any more discussion?
I have a question as to whether that ordinance can be enforced without forcing eminent domain on someone to make them.
I think the thing is, since someone's asking for a variance, and if they voluntarily do it, then it's legal.
And it saves the city later having to.
Yes.
And then the
file an
taxpayers,
and
all
the
of us.
taxpayers, yes.
So if you come up here and we ask you, hey, would you put your, the right-of-way, give the city the right-of-way, and someone says yes, that's a voluntary statement, so.
But it feels a little bit like blackmail to that owner. But if they're saying they'd rather do that than do the in lieu, I'd like to give them that choice and not make them do both.
Okay, that's what Mr. Taylor said over here. One, not both.
Yeah, I'm a little more kind of empathetic to not, if you want to give the right of way, then maybe if you have a hardship like the topography here that might help you not have to, pay a fee, but you do basically give to me that in some of these situations, that seems more reasonable.
And depending on the district, giving the city right-of-way, that's a substantial amount of money that you are giving up.
Well, and it addresses to some extent the compensation. I mean, you because of that variance, but,
I used to feel the way you feel. I mean, when I first learned about it, I thought, my goodness, how could the city take that? But that's just how it's been done. And we heard from our attorney in the past that, and even Councilman Mendez as well, who's an attorney, mentioned last time, it's just the city has the right to do that. Am I saying that correctly?
So there is case law that says that a city has the right to require this right-of-way dedication when it's something for for a specific sidewalk plan. It can't just be open-ended, but if it's for a specific sidewalk plan that exists to counteract or to help with, for example, additional sidewalk traffic. With more development comes more foot traffic, pedestrian traffic. So as long as there is a nexus between the ordinance and the requirement and what is being done. Our position is that we are, in fact, it is legal for us to ask for this right-of-way because they are asking for a permit. In exchange for that permit to counteract the additional foot traffic, for example, it would not be considered a taking.
As you said, it's not just automatic in every case. It has to be for the general welfare of the people in that area.
And the way the ordinance reads it is if you pay into the in lieu fund, or that would go to the pedestrian zone. So it's all, again, part of the general sidewalk plan that our ordinance, it applies citywide, but it's for a specific plan for the sidewalks in the city.
It would help us, and I don't know if the planning department is in a position to do that on future cases, was to know how much right-of-way needs to be dedicated. Is it a foot? Is it 2 feet? Is it 10 feet? Because dedicating a foot of right-of-way doesn't seem as egregious as maybe 10 feet, but.
well, there have been times when they want 13 feet, and your times when it's a foot, and you're right, it makes a difference.
We'll have a motion.
I mean,
I'll make one, but I don't know that you all will vote with me, but I will move that, gosh, I don't even know how to do it, I guess we don't, can I move that we follow the planning department's recommendation, which is to pay the in lieu contribution and dedicate the right-of-way?
That's your motion. Okay, motion has been made. Is there a second?
I didn't think so.
Okay, motion fails. Next motion.
Mr. Taylor, are you not going to make a motion?
I felt like I've made enough today. Yeah, I just don't, I mean, I struggle with which is, more important. I mean, the council members said they'd like to pay the in lieu fee. I get that. Somebody could convince me either way, but like I said, I obviously don't support both. And so that, I really honestly.
Would you make a motion that they pay the in lieu fee but not dedicate the right-of-way?
Or vice versa.
If someone made that, I would be fine with it.
I would make a motion that we grant the variance, however, he pays the in lieu contribution. I would not require dedication of the right-of-way.
Okay, motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye.
I'm going to shock you, and I will agree with it because I don't think, given the.
I'm going to vote against it this time.
You're going to vote against it? Oh.
Yes.
Well, I think because of the topography, they're probably not going to actually.
So what is your vote? Is your vote a yes?
So I'll vote with you all.
4 in favor and opposed?
Yes.
1. Okay, passes 4-1.
Point of clarification from the board, do we understand that to be a motion to require payment to the sidewalk fund, but not a dedication of right-of-way?
Yes.
I want to make sure we understood that correctly, and that was a 4-1 vote, so that motion passes.
Yes, okay. Next.
Thank you for doing that. Getting this unstuck.
I don't know about these sidewalk cases.
Mr. Chairman, the next case of the board's consideration is a short-term rental case, 2018-091, known as Anita Andrews, the appellants and owners of the property at 130A Kenner Avenue. Request for a short-term rental permit, an appeal based upon the denial of the short-term rental permit. Aerial photograph of the property shown here, face from the assessor's website. Mr. Osborne from the Codes Department has the information pertaining to this particular permit and its subsequent BZA case. We'll defer to him, then hear from the appellant thereafter. Is there anyone here from the public in opposition to case number 91? Seeing none, it'll be Mr. Osborne, and the appellant will have 5 minutes to make the desired presentation.
Mr. Osborne, tell us about this case, any non-permitting violations, and anything else that we might need to know.
So this permit was originally issued on 8/12 of 2016, and according to our records, it was canceled at the owner's request on 10/11 of 2016. So in 2017, on October 27th, we sent a notice of operating without a permit, and I've emailed back and forth with Mr. Andrews on November 8th. Bootsy got the letter and was asking me what was going on and that he thought he had a permit, at which point I informed him that it had been canceled the previous year. And he told me that he had not canceled it. So I forwarded down to Clint to find out what was going on, and I thought we had resolved that. Either way, the permit would have expired a year after being issued and was not renewed. So coming January 23rd of 2018, I issued a warrant. Before that warrant was served, they did remove their advertisements and have come into compliance since.
Okay. Any questions for Mr. Osborne about this? Okay, thank you. Let's hear from the applicant. Identify yourself by name and address and what you're here for.
Yes, my name is Al Andrews, and this is my wife Nita, and we live at 130 Kenner Avenue. Thank you for the opportunity to come and talk. I was telling my wife I wish I was a violinist. Things might go better. Anyway, do you have in front of you the timeline that I sent to you? They do, okay. I'd just like to go through that real quickly because I think that explains it best than talking. April 2016, we moved to 130 Kenner Avenue, Nashville from Franklin, Tennessee. August 2016, we applied for and received a permit for an owner-occupied short-term renter at 130 Kenner, and with the intent of using that money for our son's tuitions. November 8th, 2017, I received a letter dated 10/22/17 from Bob Osborne informing me that we're in violation of Metro codes because we didn't have a short-term permit. I was confused, and I emailed Mr. Osborne telling him that actually we did have a permit, and I gave him the number. Mr. Osborne responded by email that the owner had canceled the permit on 10/11/16, which would have been 2 months after we got the permit. I wrote back explaining that actually I was the owner and I didn't cancel the permit, not sure what that's about, and that there must have been a mistake, and asked him if we could rectify the situation. Mr. Osborne wrote me right back and said he was forwarding my question to zoning, and when I did not hear from zoning, I assumed everything was okay and the problem had been resolved. On February 9th, a sheriff came to the house serving us with a warrant to appear in court because I was operating without a permit. I called and wrote Mr. Osborne, and he informed me via email that my permit would have expired anyway had it not been canceled, and told me to cease advertising. And I, like the other gentleman, had gotten my permit. It said when I got it, and I just didn't realize you were supposed to renew it. Anyway, my bad there. So after talking with City Attorney Kate Pham, we put a pause on our Airbnb, and even though I was unclear of what this was about. I surmise that because the permit was somehow inadvertently canceled. I still don't know what that means or how it happened. After we got it in 2016, that's why we weren't sent a renewal notice. So I received on February 26th a letter from Jessica Shepard announcing our appeal hearing, telling us to write a letter to everyone within 600 feet of our house, which we did, put out a 36 by 24 sign, which we did. And in conversation in March with City Attorney Kate Pham, she determined, based on our particular circumstances, that a dismissal with court costs was appropriate, and we have paid the court costs of $127. Presently, our short-term rental is put on pause, and from April 2016 until the present, we have paid regular taxes on our short-term rental to the city. In 2017, we paid $3,100 in taxes to the city. So when we began our short-term rental, we contracted with MyLodgeTax.com to automatically withdraw our pay and taxes to the Davidson County Court business tax, Tennessee business tax, state sales tax, municipal tax, and hotel tax. So just in conclusion, we've enjoyed our owner-occupied Airbnb. It's been vital in helping us to pay for our son's tuition. The unit has off-street parking and has the blessing of our neighbors, and there have been no complaints, and we have 5-star reviews. Because our permit was somehow inadvertently canceled, and because we didn't get a renewal notice and frankly didn't know to renew, again, our fault, we would like to respectively request that the board consider allowing us to continue to renew our permit rather than starting the application all over again. So thank you for your consideration, and I'd be glad to answer any questions.
Okay, questions for the applicant?
Do you know anything about applying online? One of the residents here today said that it had been made easier to apply online. Is that your experience?
Actually, when we applied, we went downtown the first time and didn't know about an application online. I think it would be a lot easier because the line to get a permit is pretty big.
Well, I'm not sure if that's for renewals or a new permit.
Yeah,
so
but I
maybe
would think online would be amazing. Oh,
I
it's
can
not.
intervene for you,
Okay.
Mr. Andrews. To clarify, Ms. Sanford, I think the previous comment made in another case had to do with the app that is used to sign in to get into the codes department, to wait through the labyrinthine line to see our zoning examiners for the permits. There is no online application for either a new permit or a renewal. And
Thank you. I misunderstood
due to the
that.
complete absence of an internal IT department at the codes department, it will probably be a considerable amount of time before we have that.
And John, just really quickly, are we allowed to, or I think I already asked you, to issue a renewal, or can we just allow someone to apply?
This is an expired permit, so it's what you can do if you choose to do so for the benefit of the appellant is allow them to apply at some date earlier than the 12-month period that would otherwise be required by
But
law.
since it's expired, they have to apply again.
It did expire, regardless of the discussion of confusion over whether or not the permit had in fact been canceled. Assuming the facts and light most favorable to the appellant here say that was just a complete error, it still expired. Metropolitan government by the ordinance has never been required to send out renewal notices. We do that as a courtesy. Some folks don't get them. Regardless, you do have the ability to reduce that wait time, but we can't just turn it back on.
Okay, thanks.
Any other questions? Okay, no. We're going to close the public hearing. Thank you.
Thank you.
Here we are.
Well, I mean, to me, this is the kind of case that we've had, it seems a couple times already today, that where someone's paid their taxes, in this case, they actually thought they had a permit and didn't, and would not have received the courtesy renewal notice at any rate because it was canceled and they didn't know it. So I do have some, I do appreciate that. And with the support, I mean, I'm inclined to, I mean, I would say, 2 months, that's a week from now, but I mean, I'm almost, either that or time served, but like I said, a week from now, I think is fine. So as I see the nods, I'll move that the zoning administrator did not err and that in denying this permit, but based on the circumstances of this case, we will impose a 2-month penalty beginning February 12th, which would allow them to apply for a permit again on April 12th.
Okay, motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously.
Good luck. Thank you.
John Michael.
Mr. Chairman, the next case for the board's consideration is case 2018-92, involves the property at 1206 Meridian Street. This is another short-term rental case, an IMA appeal brought by the owner of the property, Stacy Barber, regarding our denial of a short-term rental permit at the zoning department based upon prior operation without the permit. Mr. Osborne had the case for the codes department will be able to document the dozens of stays at the subject property outside of the scope of permitted status. Before hearing from the appellant, of note, we'll ask, is there anyone here in opposition to case number 92? Seeing none, there'll be 5 minutes available to the appellant to make her case to the board after Mr. Osborne makes his presentation.
Okay, Mr. Osborne, tell us about this case. Any non-permit violations that you know of, and anything else that would be helpful to us?
So this was sent out in the host letter sent out 10/31/17. There was a unpermitted complaint filed on 11/13 of 2017. And it looks like after she received that letter, she took it off of Airbnb, but she did not take it off of HomeAway. It did not appear that HomeAway was utilized. There weren't any reviews on it. So when I issued the warrant, because on 12/4, because she had appeared to stop and come into compliance, for the most part, we dismissed that court case with cause.
Any questions for Mr. Osborne? Thank you. Okay, the applicant, please come forward, identify yourself by name and address and why you're here.
I'm Stacy Barber at 1206 Meridian Street. I guess I just didn't know I'm in the home, and I thought it was investor homes that needed permits, so I apologize for operating without a permit. I did receive the notice and took down all of my Airbnb listings. I had
About the HomeAway.
Yeah, the HomeAway had never been used, so apologies.
Why didn't you take it down?
I didn't even remember it was up. I've never gotten
Okay.
anything from it at all, so it's never been used at all. So when I got the warrant, I contacted Mr. Osborne immediately and said, hey, I've already taken this down. Why am I getting this? And he said, no, you haven't. And I said, I really have. I've contacted them. It's completely down. And he sent me the HomeAway link. And within 24 hours, I deactivated it. So I just didn't, apologies, I just didn't know that the HomeAway was still up. I'd never used it. So I went to court and I paid the fees and they dismissed it.
Okay.
What was the last day that you rented your home?
It would have been right after, or right before right before I received the notice, so October.
So the letter was October. So he said that the letter was sent October 31 and you were in compliance by at least November 13th. And so you say you were in compliance by
Yeah, I canceled all of my bookings
Okay.
as soon as I received the notice.
Any questions for the applicant? Do you have anything else to add?
I don't believe so.
Okay, thanks. We're going to close. Well, actually, let's hear from Councilman Scott Davis, who at the top of our meeting spoke in support of this and said that this applicant has not caused any extra problems outside of this one case. Councilman Davis, welcome back. Thanks for remaining with us.
Thank you, and thank the board for your stamina and being here on a cold spring day. But we've not, as you know, I used to be the neighborhood association president in Cleveland Park too, where she lives, and know a lot of neighbors around her. I mean, she's not gotten any wild parties or crazy complaints, you know, no police calls, no wild parties. So I know sometimes, and I feel like Councilman Sledge said, somewhat guilty about the writing and looking at some of the short-term legislation, and just ask the board if you can have some mercy on my constituent, please, because she took it down off the popular Airbnb. I didn't even know HomeAway for Home existed because I don't do this. So I just thought Airbnb was just one kind of big platform, but I guess there's 3 other agencies, I guess, that do this. So thank you for your time. Please, you know, time serve, or please allow her to have her type 1 permit back, please.
Okay. Any questions for Councilman Davis? Thank you for being here.
I
Close
just
the public hearing and.
I have one,
Oh,
I'm
you
sorry.
do? Okay.
Just for the applicant, did you pay your
Come over here.
taxes,
Please come to the microphone.
have you paid any of your hospitality or sales tax?
I honestly don't know how to do any of this yet. So that's why I'm going through the process. I'm hoping that in applying, I'll
Okay, you just didn't
understand
know
it.
you were supposed to have it, so you didn't know okay.
Right, I
That's what
just don't know
wanted
I don't know the process at all.
to know. Okay,
So,
okay.
Sure, Mr. Osborne would tell you later on. Okay, we're going to close the public hearing. Discussion.
Oh, the folks that don't know, that I think sincerely don't know, that come in and are trying to do the right thing, I think to me it's maybe in that 0 to 4, but even on the 4 side of that is from
October
the last known
31st.
rental would have been, 12, 13, 11, 13, which would, put eligibility at some point this month.
So motion.
I'll move that we find that the zoning administrator did not err, that the applicant is eligible to apply for a permit 4 months from the last known rental, which was November 13th, which would make that, well, that would make it March 13th. So that would be eligible today, provided that the applicant proved that back taxes are paid.
Okay. Motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. Good luck. So you are eligible to apply for a permit. We're not giving you a permit. You still have to do everything. And Mr. Osborne over there could probably give you some information on how and where to pay your taxes.
How to set that up and pay your back taxes.
John Michael.
Mr. Chairman, the next case is case number 2018-094. It involves a property at 20 Fern Avenue, both the A and B units, as shown here on the zoning map. Mr. Marsalis Teague is the appellant on behalf of Gramada Industries Incorporated, the owner of the subject property. The request is for a variance from the sidewalk requirements in this multifamily zone district, specifically the RM 20A zoning district, in conjunction with the construction of the residence. Aerial photograph here shows this area before some of the construction got underway. The site plan submitted shows the proposed layout for the construction, and from my recent site visit, the view in the lower right-hand corner, despite being a rainy, muddy day, shows the property looking back toward downtown, upper left-hand corner across the street on Fern. You've already heard from Councilman Scott Davis, the council member for District 5, specifically with regard to this and the next case, which are on adjoining lots, and the fact that there is a lot of development on Fern Avenue right now. We've brought multiple cases to you in the recent past on Fern Avenue, specifically with regard to sidewalks and in some cases setbacks. In the photographs here, merely the view up and down Fern Avenue and Narrow Street as it's presently laid out. Is there anyone here in opposition to case number 94 involving 20 Fern Avenue?
Hey, John, a question. Is it possible to hear 94 and 95 together since it's the same owner and my reading of the case files suggests it's the exact same issue?
It's the same issue. It's the same request on different properties. There are different property owners. Mr. Teague, any reason not to go ahead and just present them together and kind of have the same conversation? You think that's okay? Yes, sir. All right, no problem then. The only
Just assuming that
differentiation.
our outcome would probably be the same
That's
one way or
almost
the other.
definitely true. I'll go ahead and roll through those. Just for clarification, then case number 2018-95, also represented by Mr. Teague on behalf of Bill and Peg LLC, the owners of the property at 22 and 24 Fern Avenue. Site plan submitted shows a proposed layout. From my same day, 2 minutes later site visit, you see the proposed property there. Looking back into downtown in the lower right-hand corner, across the street in the upper left, and the same photographs of Fern Avenue there at that location. With no opposition present, Mr. Teague will have the opportunity to make a 5-minute presentation to the board. As the vice chairman rightly noted, it's essentially the same case. Just had to, because it is 2 different properties with 2 different owners, had to enter them differently. With that, we'll turn it over to Mr. Teague. Just introduce yourself by name and address, please.
Can you stay a second? I'm having trouble seeing the photos. Is there a sidewalk anywhere in this area? It looked like there was
There appears to be none there.
Okay.
And again, I can
On
let,
this side of the street?
I believe on either side of the street.
Okay.
Bad weather day. You were not listening to our local meteorologist here in our television station. There's plenty.
Mr. Chairman, as you know, bad weather does not deter the work.
Absolutely.
All right.
Okay, please come forward, identify your name and address and why you're here.
Good afternoon. My name is Marcellus Teague. My address is 1900 Eastland Avenue, Unit 201. I want to say thank you to the board and also thank you to Councilman Davis. Here requesting a variance to, obviously, as we said, not construct the sidewalks in an attempt to maintain the integrity of the neighborhood. As you can see, there aren't any sidewalks on either side of this portion of Fern, along with most of that area has been redeveloped, and that road is relatively narrow. We're also asking for a variance to not contribute to the fund in accordance with case 2017323, which was 17 Fern, located directly across the street from our property. And I would hope that this request gets granted.
Okay.
What's your hardship? Just why?
More so the topography of the lot and the narrowness of the street.
The narrowness of the street, though, would support us, well, maybe not all of us.
And the fact that
but
there aren't any sidewalks there now, I mean, that kind of,
the sidewalks help with the pedestrians. If the street is so narrow and a sidewalk is built, it does benefit pedestrians walking down that street, so they're not in the narrow road.
well, with this street, there isn't much foot traffic that we've seen out there, so that would be my response to that.
If we were to grant this variance, would you, and not have you pay, would you be willing to give the right-of-way for future sidewalks?
Yes, sir.
Okay. Any other questions of the applicant? Okay, thank you. Let's hear from the councilman, the duly elected councilman from the 5th District, Scott Davis. Please come back. I know you said at the top of this meeting you support both of these cases, but please tell us anything else you want to add.
Right. There's not much foot traffic on Fern Avenue because it's a high hill, very, very high hill. I mean, people are building houses there because they like the views. The case, that was granted, we waived the fee and the sidewalk requirement because the hill is so high and the topography is so crazy. And one thing about it, we waited for a person that was a constituent that lives on Fern and builds houses, and I treat everybody fairly. So what I asked for one, and thank you for the board for granting it, I'm going to ask for the same people building on the same street. And so I'm asking the board to waive the in lieu fee, and I'm also asking the board to please, waive the sidewalk requirements. And on the street, there have been a lot of development that's happened, and right now it would just really kind of mess up the flow. If you obviously you have a little bit of sidewalk here and then no more sidewalk. And one thing that we're working out, some council people want to keep the in lieu fees, and some want to have the in lieu fees go to their district directly if there are going to be in lieu fees. And I'm the council district that has a lot of development, have a lot of zoning bills. And if I'm going to have in lieu fees and infrastructure being done, my large developments, I make them do sidewalks with SPs and even improving bus stops. With the 150 unit one that we're doing, they're doing all the sidewalks in almost a mile area of my district. And one thing too, with the in lieu fees not coming back to my neighborhood, sometimes I have other council people, I'll just be honest, interfere in my district and want to control my development and control where my tax dollars of my citizens are spent. And so I want to be able to, if we're going to have in lieu fees, have that be spent in the 5th District where people are being inconvenient. Please don't punish this wonderful man and young lady for my view. But at the same time, I'm asking the board to, 17 Fern Avenue was granted a waiver from the sidewalk fee and a waiver from the building of sidewalk because Fern is a very tough street to build on. They're already spending thousands of dollars in infrastructure from Public Works and water fees too, and additional concrete because of the topography. So thank you for your time, and hope you all will rule just like you ruled for 17 Fern. Thank you.
Can I ask you to clarify? You said something interesting that I hadn't heard earlier, which was there might be legislation that requires the in lieu fee to stay in your own district. Did I understand that?
I don't have it in front of me. I'm not the author, but there's some legislation that we're playing with and tweaking. I want to say I have no proof, I don't have it in front of me. I think it was Councilman Glover that may have deferred some legislation to work on it. And we're kind of working on things like the act of God sometimes when someone's house burns down or gets hit by a tornado, and, their insurance won't cover an in lieu fee or additional sidewalk.
And we've been sympathetic to those people,
Yes,
by
you
the way.
have. Very, thank you. You did one for a grocery store in my district. I really appreciate that. And so now, the in lieu fee, especially when they're in the 30,000s, they send that cost onto the builder puts that cost on the homeowner, which makes the house unaffordable. Once you add that $30,000 in lieu fee, $25,000, and they pass that cost on. So it doesn't really help with our affordability issue either. And if we can't keep the funds to do an improvement in the neighborhood or even close by, if it goes somewhere else, then, we're inconvenienced with the construction and with the high housing costs without even seeing a benefit. So I think it's unfair, especially when it leaves the district.
If there was legislation passed that kept the money in your district, would you feel differently about these sidewalk variance requests?
I would feel a little bit differently. I may not want to, for certain builds, especially for small business developers, paying $35, $40, maybe $10, maybe $8,000 if I'm able to keep the money in the district. And it's not, when we say district, the city still has the money. The councilman doesn't have the money.
Right.
But, but Public Works says we have $1 million in the fund for District 5 for infrastructure, or District 2 or wherever everyone's building. I think we'll be more inclined and more supportive. At least I would.
So if the in lieu fee was less of a burden, it was more reasonable, then it would make more sense to you for us to grant the variance request, or to require them to pay into the in lieu. Is that what I'm hearing?
That's right, and if I got to keep it.
And if you got to keep it.
In the district. And I want the other district council members to keep their money too. I respect Brett's prerogative of wanting them to pay. I wish Brett could keep the money in his district for when he wants someone to pay, but that's my opinion.
Okay. Any other questions for the councilman? Thank you for being here as usual. We're going to close the public hearing. Discussion, and remember we are debating both case 094 and 095 together.
Well, what the councilman said is reasonable, and it'd be wonderful if they changed the legislation, but this is a residential area, and I think there's a safety issue with not building the sidewalks. So that's my take on it.
Mr. Taylor, didn't you ask this owner if he would be willing to dedicate right away?
Yeah, and yes, the answer was yes. The answer was yes on that. And I think the one across the street too, I mean, I think you can even see it, the one that had the historic fence that backed up to the cell phone tower. I think that was in part because it was a historic fence, and the severe topography is why the variance was granted. And I don't remember the in lieu conversation, but apparently that was one that we said didn't need to pay. I don't know if they gave the right of way.
I'd be willing to support the donation into the right of way in absent of not having to do the in lieu.
Will you make that a motion? I'll second
Yes.
it.
I make the motion that we approve case 094 and 095, and the applicant be allowed to give the right-of-way to the city and not have to pay into the in lieu sidewalk fund.
And I will second that.
Okay, motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Aye. Opposed? Okay, 4-1. Good luck. Yeah, both cases passed 4-1. John Michael, are we? Okay.
Mr. Chairman, the next case is 2018-096. Carrie Stringers, the appellant, and Brandon Rich, the owner of the property that is on consent agenda. Glad to already have that resolved for you today. Next case to be considered by the board is case number 2018-098. Coming to you from Council District Number 11, Ryan Aselby is the appellant on behalf of Music City Handyman LLC, the current owner of the property located at 4024 Main Street. The request is for a variance from side setback requirements in the thin residentially zoned property shown on the zoning map here and in an aerial photograph here for construction of a single-family residence. In the R8 zoning district, the side setback is 5 feet. Do I understand your request is for 3? The request here is for a 3-foot side setback on the subject property. There is opposition present on the case. I point here to the site plan that's been submitted to show the proposed layout for the single-family residential structure. And from my recent site visit, you'll see the view of the subject property in the lower right-hand corner, including the appropriately placed zoning sign, the tree there on the subject property line between the two properties, and the view across the street in the upper left-hand corner, and the view up and down Main Street in this part of town. Because there's opposition present, the appellant will have 10 minutes to make the desired presentation. Then we'll hear from the opposition. We'll remind the appellant if you wish to save some portion of time for rebuttal, please do so out of this original 10 minutes. With that, just please introduce yourself by name and address.
Good afternoon. My name is Rylan Ostaby. I live at 4002 University Avenue in Old Hickory. Thank you, guys. I do admire your stamina, like was said earlier. Having sit here through the whole hearing, it's admirable.
It's your stamina.
It's admirable. We acquired 211 Capitol Street, which if you look at that picture, there's that orange house on the corner of Capitol and Main Street at the end of last year. And with the acquisition of that property came that strip of land that is currently being discussed. In looking at the plot and meeting with the zoning examiner and doing some due diligence, we saw that the lot was too large of square footage to by itself get the 3-foot setbacks enacted. Apparently the lots need to be between 3,750 square foot and 5,000 square foot to get that 3-foot setback enacted. After looking at it a little bit deeper, we saw that there is a public utility on the lot, and that is a sewer line, an 8-inch sewer line. I think that you guys have the site plan, which says that, which reduces the buildable square footage of the lot to underneath that threshold that would permit 3-foot setbacks. The issue isn't necessarily whether we can build on it, because we could build with the 5-foot setbacks that are currently required. That would put a house on the lot that doesn't fit the neighborhood. Currently, there are probably 15 to 20 houses in that subdivision that are built on 25-foot lots with the 3-foot setbacks. Those are on Lafayette, on Union Street, and Hadley's Bend, and I think some on Center Street. And so to build a house that is 15-foot wide would be out of place, but doing the 3-foot setbacks would allow a 19-foot wide house, which would, I think, conform more to the neighborhood. So that is my request.
So do you still own the house to the left?
Yeah, that is going to be a renovated rental property for MCH. So we do, or Music City Handyman. So we do have an investment in that house that would be built there to be a nice house that would continue to increase the property value in the area.
So, and so I mean, I guess to me, the question is, if you own both properties, why don't you just give a 4-foot easement to the property that you own? And
Yeah, the lot that orange house and the neighboring house are actually part of a replat already, so we can't make any adjustments to those boundary lines. I looked into that as well.
So when you bought this property, you mentioned that this lot came with the property?
Yeah. So yeah, we bought the lot. It's the very corner lot, Main Street and Capitol. The house that's on the east side of that subdivision is not part of our property. But the owner owned that lot also. She didn't know. So when I inquired the real estate agent about it, she said that that would be fine to throw into the sale.
Any other questions for the applicant?
Not for the applicant, but I'd love to hear what you all just discussed.
I was just going to share it and act like I knew what I was talking about. No, I'm sorry, Bill just, it said that did we close the public hearing? We talking?
Yes. Do you have anything else to add?
No, I'm good, unless I can answer some questions.
Well, because it's just,
there's
opposition. Well, I'll just, basically, the lot is so long, it's longer than a normal-sized lot. Had it been the depth of a normal-sized lot, it would have been within that square footage, which would have made this possible by right.
Right.
And
less square footage, he would be allowed a
He'd be
3-foot
allowed.
setback by right. He's just
Well-
got more square footage than
Yeah,
allows us to give it to him under the law.
Right. So it's a strange, and it's been divided, that lot has been that small for a while. No
Yes,
one
the original
recently
Hattie's Bend subdivision from like the early 1900s.
had that small,
Yeah.
a narrow lot like that.
Yeah, all the other lots kind of in the Hopewell area are originally 25 by 150, which gives you the 3750 square footage that would make that permissible to do the 3-foot setbacks.
What's the square footage of this lot? I'm sure it's
I
on
think
here, I
it's
just
like,
haven't seen it.
it's like 5,300 something. So it's just right over the threshold.
Okay. Anything to add before we hear from the opposition? Okay, so
Thank you.
please feel very, opposition, please come forward, state your name, address, and why you're opposed to this.
Good evening. My name is Linston Starks. I am a retired 24-year veteran. I live in 165 Ethan Moore, Georgia. Myself, along with 5 of my other brothers, inherited the lot that you see, the brown house is to the right of the tree. That's the land that the estate that my mom left us. She recently passed away. 2 of my other brothers are veterans. One of my veterans is a disabled veteran. He lives in the building there. The reason that we're opposing it, one thing I do want to make a note of, the property is in all of my brothers' name. I myself, that live in Georgia, have a P.O. box. I did not receive a notice of the intent to get the variance. The only reason why I'm aware of the variance is because there was a sign in the yard, and my brother, that's a disabled veteran, saw the sign laying on the ground, and he took a picture of it, gave it to my aunt, and my aunt contacted me, and I'm traveling back and forth from Atlanta to take care of this.
So why are you in opposition to this?
The reason we're in opposition of it is because of the variance that he's trying to, what they're trying to do is they're trying to put the house close to our property line, which they have that property, the little orange house that they have there, which if they're going to build the house, why not build it closer and not toward our property line onto their property line? I've also brought some information that I wanted to have in evidence, which you can't see based on the, excuse me. You can't see based on that illustration up there. If you take your time, there's enough for each one of the council members. If you take a look at the lot number 1, as he was talking about, the gentleman was talking about earlier, each one of those strips are the different lot size. Then they vary in size. If you go down and look at lots 9, 8, 7, and 6, my grandfather purchased that land, and that's where his house was built on, and that's the lots that our mother's house is built on. That lot that we're talking about is lot 5. So those lots went all the way back to the back, and what my grandfather and what my mom did was they built that house within all of those lots, not going within the property line of anyone else. If you look at the second photo picture here, which has this one right here, which has a picture in orange which shows our property, where you can actually see almost all of the property lines. If you notice the strip that they're talking about building a house on, you see there's another house that's built back there, and they've got a fence that's over the property line, which that property was recently sold, that was owned by MCH, Music City Handyman, which is affiliated with Global Development, which that fence, I'm assuming that fence is going to have to be tore down because it's actually on over our property line there. The house that they're talking about, which is over, that you can see in the illustration over the top view, which is 123, they could take, as far as the variance go, they could move and build that house if that's what they want to do, and build it within their property line, even though they're trying to rent out that other piece of property right there from the Orange House. It has, for them to circumvent the law, which the law states it's got to be at least 5 feet from the property line, just to invade and impede on our property, which some of the factors that are that's going to affect our property is that it's going to be, that lot is going to be overcrowded if they try to squeeze that 19-foot house on that 25-foot wide lot, and it's going to be within 3 feet of our property. If we wanted to put a privacy fence up, we'd have no ability to put a privacy fence up. If you look at the second page behind that, that's particularly one of the types of houses that they're putting there. Those houses that they're building, which he mentioned earlier that some of the other lots that they build in our community are within 3 feet, that's because, one, they haven't had anyone to actually oppose what they're doing, and two, they're building houses like this, which are so tall, which are going to block off sunlight. This house is going to be directly close and near our property. So I am opposing, and along with some of the other neighbors that are here that are coming to speak too, are opposing allowing this variance within our property line, and they already own the property to the left of it, so move it on their property and build the house that they want to build there.
And I mean, I appreciate you coming and sharing the history of the land. I guess I'm curious to know why you couldn't build a privacy fence, because it's, it seems like you should be able to build you can build a fence on your property line.
What purpose is it going to serve? It's going to sit too low. The house, this house.
You wouldn't have privacy.
You wouldn't have any privacy whatsoever.
I'm sorry. That's what I wanted to clarify. Your issue is that you wouldn't have privacy, not that you wouldn't be able to do it, because you could build a fence, but it would give you no privacy.
We wouldn't have any privacy. The other thing to add to that is once they start that construction, like they were showing earlier with the tree that's there between the two property lines, they're going to be affecting our property.
Right.
Okay, which means the roofs, if they have to remove it, if they have to tear it out. There is one tree that you can't see that's in the back, close to where the fence is, that's actually rotten, which is going to affect where they build that house, which they're going to have to tear that out. And to be honest with you, if we could stop them building a house there, I would rather stop them building a house there because of what effect it's going to have on our property. But I'm not sure we can do that. But as far as the variance, the law states that it has to be a certain distance. They own that property to the left of our house. There's no reason for them to impede close to our property line, period.
I have a question. I want to make sure I understand this drawing. The very first page that you handed us, and those lots have numbers. You can barely read them, but I can read 5, 6, 7, 8. And 9, and are you saying that your family owns 6, 7, 8, and 9?
Yes, ma'am. That's where that house, our house, is actually built on.
Thank you.
And the lot that they're in question, I'm not really sure. Initially, that lot was not on the same deed. For some reason, the young lady that owned the property, which we know them and their family, we grew up with the lady that, Miss Sarah, that owned that house that they're talking about renting out and remodeling. And we actually maintained that lot since I was a child. No one else maintained it. We was responsible for it, so we assumed, based on me being young and getting a little older, that we assumed that we owned that property. But when this came about, no one was aware that that property was not deeded as part of that house at all. It was just by itself. If I had known that, then I would have purchased the property. So because we've been the only family that's been living there since my grandfather then left, moved out of there, and then my mother, he gave the land to my mother, and they built a house there and raised us in in that house, on that property. So we would have purchased it, but to allow them to build a house that close to the property line where they have property over there, just put it close to their own house, or don't build anything. Just because the lot is long and you're using square footage based on the length, that's still going to be a problem with us with privacy. I mean, we're not going to have any privacy when if that house is built there.
Right, and I truly appreciate it, but the point that we were making, and I think you just had said that you mentioned the length, was that if the lot was any shorter by, I don't know the exact footage, but if it were, say, 20 feet shorter, if it was just slightly shorter, then they would be within that square footage where they could build this exactly like they want to without having a variance. And your concerns would still be valid and real, and so that's kind of what we're trying to struggle with, is that, if they're looking at, 3,700 to 5,000 square feet is that window where you can build this with a 3-foot setback, and they've got 5,300 total, is that extra 300 feet worthy enough to give them a variance? And I fully appreciate your opinion that it's like, I don't want them to have the variance. I mean, I understand that, but I just wanted to make sure that you knew that that's the main issue that we're looking at. Although, and like I said, the neighboring property is important too, because I raised that with the applicant to say, well, why didn't you just?
So the variance of the close proximity of the property line, which the code in law states is 5 feet.
It's 5.
It has nothing to do with, so you're saying the square footage has something to do with?
It's 5 feet. It's 5 feet on that 25-foot lot because there's 5,300 total square feet in the lot. Okay. If the total lot had been 5,000 square feet, or maybe 4,999, I mean, the code staff will tell me exactly what that is. But if it had been 300 feet less, then they could do exactly what they want to do without coming to us at all. So they could have a 3-foot variance. So it's just because, and then what we have to decide is it unusual to have a lot that long? And if it is, then they may have a case to warrant a variance. I mean, we haven't gotten to a discussion, but that's just how we have to look at it, and how we will. But I totally get everything you're saying and appreciate it. And I just wanted to make sure you knew if we were talking about this, that it wasn't. Again, I don't know where it's headed, but I didn't want to feel like anything was disrespectful to your thoughts. But that just was the comment that I'd made earlier, and I just wanted to make sure that you knew why we were considering 3 feet versus 5 feet in this situation on this lot.
So based on the length of the lot and the size of the lot, if you allow them to build on it with the 3 feet variance, they're going to be able to circumvent the law because the law doesn't allow them to do that, correct?
Yeah, well, we, as a board, what we do is apply variances to the rules, and the variance would be because there's a specific hardship or situation that would warrant it. And so this board would have to decide, yes, there's a reason that this specific property is unique and deserves a variance or a variation from the rules that apply to most pieces of property. And that's what we do all the time. I mean, that's the whole point of this board, is to say, every case that's come up before us has said, the rules require you to do something, we want to do something different, and we have a good reason. And that's the only reason this board exists. So anyway, I just wanted, like I said, it's not for us to get into a debate over it, because each of you share your opinion and then we talk about it. I just wanted to, since you were coming from out of state and it's a family property and it's important to you, I just wanted to make sure you understood the issues that we're trying to look at.
Okay, then I want to just read one thing to you. The Court of Appeals cited an abundance of cases holding that a small lot of size alone can never excuse overbuilding just so an owner can acquire as much living space as possible. This is cited court cases. The individual circumstances of MCH, Music City Handyman, cannot form the basis of a hardship. Otherwise, the diminishable zoning regulation would not be it would be of no effect.
Right. Okay.
Okay. He said, are there other people here in opposition for this? Well, You have about 3 minutes and 30 seconds combined, so if anyone wants to speak in opposition, now is the time.
Can all the opponents raise their hands?
Yeah, raise your hands. The people that are here in opposition, please raise your hands. So there's about 5 total. Okay, thank you. Identify yourself for the record, name and address.
My name is Doris Hadley. My voting residence is 4844 Matterhorn Drive, Old Hickory, Tennessee, 37138. I'm here on behalf of my 6 siblings and I regarding property on 4025 Main Street, Old Hickory, Tennessee, 37138. Thank you for allowing me this time. The hour is far spent. Briefly, I'd like to say that we're in opposition to the request of the appellant. This construction would adversely impact the normal layouts of homes that are presently located on Main Street and those on Capitol Street. You'll have before you different pictures of the layout of our street on Capitol and Main Streets. More specifically, adjoining homes have spacious sides that exceed the 5 feet requirement. We also have spacious front yards and backyards. We think just such a construction would simply be an eyesore, a great eyesore. Number 2, it would also obstruct the open access to the sun, which rises on the east side of our home. During the seasons of colder weather, we depend on this natural energy-saving cost to our heat bill. This east sunrise also allows for health-wise benefits as a direct source of vitamin D. The pictures that you have, it shows the multiple dwellings up on Lafayette Street. And on Lafayette Street, we have this Global Outreach Development Company that has come in. And when we see this request, we look at the conglomerate of houses that do not fit the normal layout. And so we're requesting that we pray and hope that our reasons are sound and opposition requires.
Do you live across the street? Do I understand your address?
Yes, we live across the street. And on one of the pictures that is on the PowerPoint, you can see our house. It's our dad tended to trim it in black, and it's white brick, so it stands out. But yeah, we have plenty of space. We're used to that, and so we're asking you to please consider our opposition to this.
Any questions for the opposition? Okay, thank you. If there's anybody else that wants to speak, there's only 1:09 left. Please come forward, state your name and address and why you're in opposition.
My name is Frances Pratt, and I currently live at 134 Lakewood Road in Lebanon. However, I do own the property, which is located within the 600 feet of where they're wanting to build this structure. And that property is located at 220 Capitol Street in Old Hickory. I will be very brief. From looking at the plans that they're wanting to construct there, I just want to say that I think that this plan will destroy the rhythm that we currently have in our neighborhood. Thank you.
Okay. Anyone else wishes to speak in opposition? Okay, we'll have the applicant come forward again and speak for rebuttal.
I think on behalf of MCH, I'm sympathetic to what you guys are saying. As a member of that subdivision, I actually live in Hopewell, and I live just a few blocks away. We had homes that were being built right across the street from us that definitely did not conform to what Hopewell looked like in 2009 when we first moved in there. The neighborhood is changing, and it's not MCH that's doing it. We've built, I think, 3 homes total there in that subdivision. I think the 19 that have gone up are not affiliated with MCH. I can say confidently that if we'd be willing to have any conversation necessary to make sure that the tree, any disturbance on your property would be we would make sure that you guys are taken care of and feel good about it. If you guys are wanting a fence to be put up, we would definitely help with that as well. As far as it obstructing the sunlight, the house would be directly north of Mr. Stark's home, I think, right? Yes. Yeah, it's directly north, so it shouldn't necessarily impede that. Also, that lot is a corner lot, and there is no other fencing around, so I'm not sure how secluded it is at this point already. I think all the facts are there, so if there's any other questions, I can.
Well, I guess the one thing I have a question about is that, you know, I mean, that one of the criteria is no injury to neighboring property, and you've got a lot of neighbors saying it's going to impact them and their neighborhood, and so how do you meet the requirement there?
I'm not sure I understand the question. Are you
I'm
talking
saying
about in
when-
terms of
I'm talking about
construction?
the standards for a variance. You know, I mean, you've argued that the unique characteristics of the plot itself, and I certainly I can see that, and I think, but if you keep going down the list, one of them is no injury to neighboring property, and sometimes a measure of that is the intensity and impact that the folks who own property right next to you have, and they've all come out saying they don't want it. So,
yeah, I guess I should have had some of the other neighbors write some letters to you. The home that is on the northeast corner of that lot are in favor of it. They had briefly brought up the fence issue. That fence that does go into, I think, your guys' property is actually that house's. I helped as an agent them acquire that house. They're familiar with the fence. It's definitely not just housing their lot. It actually goes over into MCH's lot, and it probably does go into yours. I'm not sure. I haven't looked at it, but they're aware that that's going to have to come down and be moved to be in compliance. I think that we'll do the best that we can to make sure that we are as low impact as possible through the building process. And as I said, these style of homes, while they're not traditional to, or native to the area, they're about 15, 17 of them already in the neighborhood. So they're not, it's not out of characteristic for that subdivision.
so would you consider a 5-foot, no variance on the side of the property owner that spoke, and a 3-foot variance on the other side, which would require a 2-foot easement from the other property you bought? Or just a 3-foot, a 3-foot variance, however you accomplish it on that side, but no variance on the neighbor who had the issue with the 3-foot.
Yeah, I wouldn't be opposed to that. Like I said, we own that lot to the north. Maybe if we could apply the 3-foot setback rule, but allow us to build on the lot line to the north, and then we could have 6-foot off of that side. I know that's a different variance, but it would be up against a piece of property that we currently own and that we're not letting go.
I was actually going to suggest that when we deliberated, but how many stories will this new home?
It's 2
proposed
stories.
new home?
I think that the site plan, I know that the site plan does have an elevation on it. I think it's 28 foot tall or something like that. That's to the peak of the roof. I have the full site plans here. And one of the things I don't think was included to further demonstrate hardship is that sewer line that runs through the front of the property, which minimizes the buildable space.
You're kind of maximizing the width of the space. I'm not sure I understand the buildable. You talking about you would make it longer, and I mean you'd make it longer and skinnier?
No. The building footprint would stay the same. We're looking just for the setback to not put a 15-foot wide house. 19-foot wide is what is common in the area, and so we're hoping to be able to build to that width.
Okay.
Well, any more questions of the applicant? Anything else to add?
No, sir.
Okay. We are going to close the public hearing. So we've had creative suggestions. I appreciate the opposition coming here and supplying us with this information too, which I thought was very helpful as well to kind of understand this little area and these streets.
Yeah, I mean, you know, I'm respectful of the neighbors' concerns, and yet at the same time, the homeowner or the property owner has a right to build something on the property within the rules that we have. And so, I mean, I know it said maybe a 0, but I mean, I really, and I think the applicant did say they were willing to consider an easement, so I'm, you know, willing to provide a 3-foot setback on the north side of the property, which is adjacent to the property that the applicant currently owns, and no variance on the south side of the property, which is the property line of the neighbor who spoke, whose family, I think he had said he owned the lots 6, 7, 8, and 9, that property owner.
If I understand that correctly, though, that'll make his home skinnier.
Well, I think it would be two choices. The property owner could make the home skinnier, or the property owner could, through a very simple easement document, get 2 feet from the property that he already owns and have 3 feet to the property line. And so it would be the property owner's choice.
Okay. More discussion, or should we try to tackle a motion?
That makes sense as long as he's not forced to make the home skinnier, because I think that is more detrimental to the neighbors.
How so?
Because if the house gets skinnier, it will look even more disproportionate to what their homes are. So I was trying to go after giving him as much width as possible, so it doesn't get taller and skinnier.
I don't think that really matters. It's so out of character with these houses that we've seen the pictures of that I don't think that really matters a lot. Just my view.
I don't disagree, but it's still a buildable lot, so.
As I understand what David's saying, though, if we deny the variance on this side, that he owns this lot, he can give himself an easement so that he still has the width. It just comes on the other side.
Okay, yeah, if that's what you understand, as long as we're not
That's
forcing him.
how I understand it. He has a choice.
Yeah, and I just.
He doesn't have to, he could build it skinnier, but if he wanted to maintain it, he can give himself an easement on this.
Well, or you could, I mean, if that's a concern, we can ask the applicant if they're amenable to the easement with building the 19-foot wide home. And that's what I just asked. I mean, the home itself would not be over the property line. The home itself, in this scenario, with 6 feet of total side setbacks, you'd have 5 on one side and 1 foot on the other. And I would just say, in order to have a reasonable separation between any use of that property, that they secure 2 feet and fence it. And that, I think, is okay. And so if you're concerned about the 19-foot home, then we just say, well, no, you got to build a 19, you can have that 3-foot variance if you build a 19-foot home and secure a 2-foot easement on the property you already own.
Yeah, if that works. I was just going to keep it simple and allow him to have a 1-foot setback from that property line.
Yeah, and that's all, and that's all, I'm essentially saying that too. I just don't want.
He's just saying down the road, if he guaranteed an easement, then that other, there would always be the 3 feet.
There'd always be 3 feet, and then at least between the homes.
Okay. That's how I understand it.
Yeah, and that's my intent.
Okay, that's fine.
And is that okay if we open the public hearing, just so
Okay, we'll open the public hearing.
Sorry.
Thank you guys so much for considering this. So from what I'm understanding, that we would move the house north up to 1 foot of the boundary line, the north boundary line.
Yes,
And then
and have 5
we would,
feet.
from our own property to the north, secure a 2-foot easement to
Yes.
make sure that there's a permanent 3-foot setback from the house.
Yes.
Yeah, that makes sense.
And then you would be 5 feet from the south neighbor that was
Yes, sir.
concerned about the distance. Okay. Then I will move that we approve a variance on the north side of the property, a 1-foot variance with the condition that the property owner secure a 2-foot easement from the property that he currently owns, which I believe is 211 Capitol Street, for the length of that property, to secure a 3-foot variance, or 3-foot setback on the north side of the property, but the south side would have a 5-foot setback from the property line.
Okay, motion has been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Opposed? Passes 4-1.
Mr. Chairman, the next case for the board's consideration.
Break.
The board will take a short break and reconvene with case number 2018-100 after the break. Mr. Vice Chairman, with your permission, given the advancing hour, we'll go ahead and reconvene since we do have a quorum present. Chairman will join shortly. The next case for the board's consideration is 2018-100. Michael Giles is the appellant and owner of the property at 1000 Warren Street, unit number 106. This is an item A appeal involving a short-term rental property and denial of the short-term rental permit. Aerial view of the property shown here, face of the property shown here. Mr. Osborne has the case for the Codes Department and will provide the overview to the board of the case and the basis for the denial of the permit. Then we'll hear from the appellant. Is there anyone here in opposition to case number 100? Seeing none, the appellant will have 5 minutes to address the board when the time's appropriate. Mr. Osborne.
So this case was brought to our attention by Host Compliance. It was sent a abate letter on 10/27/17 for operating without a short-term rental permit. It had been in operation since May of 2013 and had about 517 reviews. On 125, or on around 125/18, I issued the warrant because the property was still in violation. By the time that the warrant was served, it appeared that he had removed his advertisements and had applied to go to the DA. So we dismissed our court case last week so that he could come here. But since then, as of yesterday, there was a live advertisement with more reviews from February and March. So we have reinitiated that case.
So you've reinitiated the case to environmental court?
Yes, sir.
I guess the question for our legal counsel is, if you have a case pending in environmental court, is that something that I guess we should wait until that plays out, or do we go ahead and hear this one, or?
I think you can do it at your discretion. There are two different issues. The ordinance gives this board the authority to hear cases for denial of a permit, which is one issue. The ordinance gives the court the authority to hear alleged violations for operating without a permit. So there are two different issues. I think you can defer this until after environmental court if you want to, or you can go ahead and hear it, rule on it, but that would not preclude us from going to environmental court.
Do you know what the date of the next hearing is for environmental court?
Just reissued it yesterday. It's May 9th.
May 9th.
Because part of that, or the reason it was dismissed, was based on compliance and his admission that he had stopped.
Okay. I think this is maybe a question that the board should discuss because of the nature of environmental court and the pretty dramatic difference in penalty. And
I will say the way that the penalties would work, if this board imposes one penalty and the court imposes another penalty, they would, because they're two different issues, they would both be valid penalties. They would just run concurrently. So if this board imposed whether you imposed 3 months or whether you imposed a year. And then if the environmental court imposed 3 years, they would both be valid. They would just run at the same time. So
Right.
once this board's penalty ran, if there were an environmental court penalty, it would continue to run until it runs out. It wouldn't be stacked. It would be, they would run simultaneously.
Yeah, and just to bring our chair up to speed, Mr. Osborne had told us that the applicant had received an abatement letter on 10/27. On 1/25, a warrant for environmental court was issued. The applicant removed ads, and that case was dismissed. But yesterday, Mr. Osborne looked again on the case. The applicant had a live ad with February and March reviews, which suggested that it was rented in February and March. And so they have issued another warrant for a case that's going to be heard on May 9th. And the question that I'd asked before we heard from the applicant was, is this a case that we would want to defer until after the environmental court hears the case?
Yeah. I say yes.
And I just had asked the board that question when you came
And the
up.
reason, to me, we've heard cases earlier that environmental court dismissed, and I think they're very deferential to us. And, if we hear something, they'll basically say, well, they heard it, so we don't have to. Word to the wise of the people out there, we start with a year penalty here. That's the maximum that we can do. Environmental court, if you're found guilty in environmental court, it's 3. That's what the legislation says. So given that they got to leave environmental court and come here once, and then there's new evidence, I say go back to environmental court and take your chances there. And we can always hear this case if environmental court dismisses it or rules or whatever.
So
So
if we were to move to hear this on the May 17th meeting, then we would have an answer from one way or the other from environmental court.
And I would instruct our Metro.
One point, yes, you could you could defer to the May 17th meeting, assuming, or provided that there's no, assuming there would actually be a hearing and that there wouldn't be a continuance for some reason or other. There's no guarantee. It's set for
Right.
May 9th, but that's the first setting.
Yes.
So,
What I would also do is, if there was any question for the record for Metro Legal, is we want environmental court to hear this particular case first before we hear it.
I would just defer to this board. I think that if you want to let the environmental court go ahead and hear it and rule on it, then that's fine.
We do.
Well, I have a question. Is there any benefit to environmental court if we hear it? Would they?
Well, here's the thing.
Two different issues.
So this is my just kind of opinion on how all this has worked and just watching this in the past. If we have environmental court, if we hear the case, environmental court feels like they don't need to hear the case, because a lot of the cases, once we hear it, they don't. I'll ask our lawyer.
Two different issues, so.
Usually, if we hear a case and someone's pending in environmental court, kind of what happens? Does environmental court take the case anyway, or what do they do?
Again, it's two different issues, so I think it's to consider on a case-by-case basis.
What has been your experience in the
I think in this
past?
particular case, it would probably proceed in environmental court.
Even if we heard it?
Yes,
Why do you say that?
because it would be a repeat offense.
Even though environmental court dismissed it?
Roberts, well,
We
they
agreed to dismiss it because it looked like he
Right,
came into compliance. As of yesterday, when I rechecked it to present it here, it was not in compliance and it appeared to
Personally-
have operated since then.
I will say, Metro Legal's position would be that it should proceed in environmental court.
Right.
There's of course we can't guarantee
Personally,
what the
I
judge
would
would do.
feel
but-
more comfortable if this just go to environmental court.
And defer it to the May
And then we could always hear it later.
I'll move that we defer this case to May 17th.
Okay, and I'll second it. Motion's been made, properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Okay. May?
Mr. Chairman, the next case the board's consideration is 2018-103. Terry Vo is the appellant and owner of the property located at 18 Claiborne Street. The request is for an item A appeal involving a short-term rental permit and denial of the permit application. Aerial photograph of the property shown in this photograph and the face of the photograph shown here. Again, Terry Vo is the appellant and owner and will be the appellant on this case. Is there anyone here in opposition to case number 103? Seeing none. There'll be 5 minutes to make the desired presentation to the board. Please come forward and introduce yourself by name and address.
Oh, yep. Mr. Osborne, tell us about this case, any non-permitting violations, and anything else we need to know.
So, no, there weren't any other complaints about this property. We sent them a abate notice on February 9th of 2018. Somewhere around February 25th, the advertisement was removed, and since then they've appealed to come here. It doesn't look like they've had any activity since they've taken their advertisement down.
So this was the case that Councilman Sledge talked about at the front of the meeting and said that basically they were a day late of sending this in. So, to refresh our memory. Any questions for Mr. Osborne? Okay. Please come forward, identify yourself by name and address, and tell us why you're here.
Hi, good evening, Chairman and the board. My name is Terry Vo, and I live at 18 Claiborne Street, Nashville, Tennessee, 37210. Thank you for the opportunity to speak, to allow me to speak with you all today. Just like Mr. Osborne said, I did not know that I needed a permit, and I apologize for not getting that permit. And I come before you today wanting to be in compliance and do the right thing. I'm a new homeowner, and so I'm learning a lot in this process. So when I received the notice from Codes, I immediately contacted Councilman Sledge to understand what I needed to do, and I learned that all properties, regardless owner-occupied or non-owner-occupied, require a permit, and I immediately went to Codes the next day to try to apply for my permit. And when I went, the examiner explained to me the process and told me he denied me the permit and that I could, appeal my case. As soon as I finished the meeting, I removed my listing, informed my neighbors, my sign is in the yard, and I've had no complaints. I pick up my trash. I'm involved in revitalizing our neighborhood and our neighborhood watch, and I just want to comply and be a law-abiding citizen. And I've learned a lot through this process, and I want to help other people not have to go through this and not have to use your time serving our city. So I just am requesting.
Thank you. We, like I said, heard from Councilman Sledge, who actually wanted us to just grant the permit. Any questions for the applicant?
When was the last time you rented the property?
It was before, in February, like before before I removed it.
February what? Do you know?
The beginning of February. And then I received the notice, and then I took it off.
Okay, would it be safe to say like the 6th, the 7th? Mr. Osborne, do you know?
Well, you said the letter came the 9th.
The 9th.
Okay, well, let's just say the 7th. We'll say the 7th. Okay. Any questions for the applicant? Okay, thank you. Going to close the public hearing. So, as I said earlier in the meeting, Councilman Sledge is in one of the top 4 short-term rental districts. And as you know, board members, most of the time, he's here saying, enforce the law, force the law. And, this time, he said this applicant was a day late and said, she's talked to me wanting to comply, and it was his recommendation that we allow this. So without any other things, I would like to make a recommendation or a motion that we uphold the zoning administrator did not err, but that this applicant should be allowed to have the short-term rental permit on April 7th. To not have it, to apply. To apply. Okay, motion has been made, properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye, opposed, passes unanimously. You are eligible to apply on the 7th. You don't have a permit, but take all your little papers and make sure you do it right this time. Thank you. John Michael.
Case 2018-105 involves Kelly McGrath, the appellant and owner of the property located at 1523A McKinney in East Nashville, Council District Number 6. You've heard from the district council member on this subject. It's an item A case involving a short-term rental permit and the denial for such permit based on prior operation. The appellant is present. Is there anyone here in opposition to case number 105? Seeing none, the appellant will have 5 minutes to make the desired presentation after we hear from the Codes Department staff with regard to the violations and subsequent denial of the permit. One moment for that, please, Mr. Chairman.
Okay. Mr. Osborne, tell us about this case, any non-permit violations that you might know of, and also anything that we might need to know.
No other complaints that I'm aware of. We sent them an abate notice on February 10th of 2018. And it looks like the advertisements were removed approximately 2/21 of 2018. Been in contact with her, told her how to go navigate through this process, made sure that she knew not to, advertise or keep operating in the meantime.
Was this a host case? How did we hear about it?
Yes, sir.
Okay.
Well, and this one has probably the strangest history of any of them that the host report shows. I mean, it shows one stay in January, and then it was, it was listed, it wasn't listed. You had a few stays in 17, then it was listed, it wasn't listed, and then, it sounds like there was not a whole lot of actual rental activity discovered on the property, maybe 10+ listings. Is that?
There is 12 reviews on Airbnb, and then on HomeAway. I'm not seeing any on HomeAway, so it looks
Okay.
like 12 on Airbnb.
Okay, yeah, no, I'm liking the reports that y'all are including from host, and that's what, it's the one that the rest of them were like 10, 10, 10, 12, stays, and this one was listing up, listing down,
Okay.
all over. Anyway, thank you.
Any other questions for Mr. Osborne? No, thank you. We're going to hear from the applicant. Please come forward, identify yourself by name and address, and why you're here.
Hello, my name's Kelly McGrath, and I'm here to appeal this. So I've been living at the property for the past almost 2 years, and it's a duplex, and I just bought it December 22nd of 2017. So, and it's my first property. I'm a new homeowner. And during the time that I was there, I'm a touring musician. And during the time I was there, my landlord, who owned the property, had suggested Airbnb my place if I was okay with it, which I was. And in turn, go towards my rent. And just did it a few times, and then I was home. So that's why there was only a couple times. And then, I wasn't comfortable with it anymore. And then in November, when I got home from tour, he decided to sell, and I made him an offer and closed December 22nd. And I was unaware, like I said, this is my first time purchasing a property. I was unaware that there needed to be any permit. And I rented it to one person for 3 days at the end of December, and then they left a review. And then through a mutual friend, this girl who was producing on the Kelly Pickler show on CMT was just looking for originally just 2 months, and then the next month she was like, I'm looking for actually through April 15th. So since I bought the place, I've had a full-time tenant in there, and I've just blocked out all the dates.
You mean a full-time tenant, longer than 30 days?
Yes, sir. She's been there since January the 2nd.
Okay.
And she's there until April 15th. And I totally forgot about it even being on the sites. It's never been rented on VRBO. It wasn't even active, and I blocked out all the dates through the summer, and I guess that's why I never got a request for a booking.
When did you block out the dates?
In January.
Okay.
I blocked out all the dates through May, because she said she was going to stay through April. And then a friend of mine said, you know, you have to get a short-term rental permit in order to rent it out. And I was like, oh, okay, well, sure, I'll do that. But I was going in and out of town, and I didn't think I needed the urgency because it was rented out through April. And I was like, I'll get to it in February, because I was gone most of January. And then when I came home the first week of February,
And you have a letter waiting
I
for
had
you
this
from
letter. I know, and I
Mr.
called
Osborne.
him. I called him freaking out. I was like, "What is this? What have I done? I mean, I haven't rented it out. I have a full-time tenant." And he was like, "It doesn't matter. The fact that
It's the advertisement.
and
is
I
the
was like, I didn't know that. I'm so sorry. What do I need to do? So I called him immediately, freaking out, because, you know, like I said, I'm new at this, and I want to abide by all the laws, and I travel a lot. So I was completely unaware that I was violating anything, having it up on the site. So
everything's down now.
oh, I took it down when I received the letter the second week of February, and I went up to the zoning board. I didn't even know I needed to take it down. I just said, what is this? What do I do? And they advised me to file an appeal. And he said, David, he said, have you taken your ad, your whatever you're listing down? And I was like, no. And he said, you do it right now. And I did it right there in front of him. So
Questions for the applicant? Anything else to add?
well, I would just really love to be able to apply for a permit as soon as possible. I'm leaving town again on Monday for a few weeks, and my tenant moves out on April 15th. So I would appreciate the opportunity to apply for a permit as soon as possible.
Okay, thank you.
Thank you.
We're going to close the public hearing. Discussion.
Yeah, I mean, this is in that very minimal offense category, so I'll move that the zoning administrator did not err denying the short-term rental permit because of the advertising, and that the applicant is eligible to apply for a permit tomorrow.
Okay. Motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. Tomorrow you are eligible to apply. You don't have a permit, but you're eligible, so you could go down there and see what they say. John Michael.
Mr. Chairman, the next case for the board's consideration is 2018-107. This is, although the last regularly docketed case, you will recall that there was one case from the top of the agenda that we pushed to the heel, and one other item previously heard where you wanted a little more information, also available at the end of the docket. For now, 2018-107 involves a property at 3813 Logistics Way. Brad Garrett's the appellant on behalf of CH Realty, the owner of the property, out in Council District Number 33. Just off of Old Hickory Boulevard. This is a request for a variance from the sidewalk requirements, and this, the IR zoning district, in conjunction with construction of a warehouse. The aerial view of the property here gives a layout of the very clearly industrial nature of the area along Logistics Way. From my recent site visit, you see the construction well under development at this point. The view up and down the subject street at that specific address. The view across the street at that location. Is there anyone here in opposition to case number 107? Assuming, of course, that no one is. There'll be 5 minutes made available for Mr. Garrett on behalf of the appellant's group to make the desired presentation to the board with regard to the sidewalk variance. Please just introduce yourself by name and address.
Okay, please come forward. Maybe not.
On the off chance that the appellants are presently at the Sunny West Conference Room, completely baffled at 5:49 p.m. as to where the rest of us are, staff would respectfully suggest allowing them to defer this to a later date. Again, just in an abundance of caution.
Then, once again, not the May 3rd date. Okay?
I mean,
I believe May 17 is the next docket that we have that is not presently jammed with about 1 million cases.
So May 17th? Yep, let's defer to, I'll make a motion, we defer to May 17th.
Second.
The motion's been made, properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Opposed? Passes.
Mr. Chairman, we'll now take up case number 2018-069. This is a short-term rental case involving the property at 1208A Shelton. Steve Dumas is the owner and appellant of the subject property. This is a short-term rental case where we deny the permit application based upon prior operation. As I mentioned to you somewhere back around 1:30 or so, there is some reference to the accessory structure and the question of whether or not it is eligible for residential use. That's a separate consideration that zoning staff will take up only after the board makes its determination with regard to the short-term rental permit. So all that's before the board today is the question of the short-term rental permit, the present 12-month wait period that is in place for its next permit application, and whether or not that period of time should be reduced. Steve Dumas, as noted, is the appellant and owner of the property. He is present. There's no opposition present. Mr. Dumas, you have 5 minutes to make the desired presentation to the board. Just come over to the microphone and introduce yourself by name and address for our record. Thanks.
Yes. My name is Steve Dumas. I live at 1208 Shelton Avenue. I bought the property in February 2 years ago. The structure that he was speaking in the back is a 2-bedroom apartment, converted garage. When I purchased the property, I went down to codes, and that place had been updated in the 80s, so I immediately rented it out as a long-term rental, while the house the front structure was being remodeled. I subsequently moved in there, and in June of last summer decided, when they moved out, to do Airbnb. I am visually impaired. I have a degenerative eye disease, so I don't see well enough to sort of navigate, so I hired someone to do that. And thought that it was done until I found out, and I believe I couldn't really speak to the date when it was mailed out, because I believe the initial letter came to the 1208A mailbox, which I didn't really check or have someone check, but November is when I sort of discovered it, I guess, and spoke with Mr. Osborne, and so I went down to try to handle it immediately. The challenge that I had was that I guess they're so overwhelmed down there, they have this sign-on online, and really no matter how many times I tried, because of the delay in me getting the information, the data entry, I just sort of never made it. So it took me a little longer than I would have liked to sort of address it, but I went down there, I waited in line a couple different days. They said 6 to 7 hours, no guarantee, but I kind of went through it. But when I saw that wasn't going to work, I just immediately went and handled the taxes and tried to get my business license. And so I sort of did all that back then. After I went to court and they dismissed it, Mr. Osborne was actually super helpful in sort of helping me navigate what to do next. So I sort of started that process. It's been shut down since December. I've not had any bookings, however, and actually someone with him told me sort of how to go into the Airbnb, because I had someone take the pictures, set up the website, basically do everything. And when I recently did get a booking, oddly enough, a couple of weeks ago, or last week, and I immediately canceled it because I thought I had extended the snooze period, but I hadn't, so I immediately went on there and did that. But I've had no rentals since the 31st of December was my last rental, so it's been empty. And that's pretty much it.
Any questions for the applicant? Okay. Thank you for being here.
Thank you.
We're going to close public.
Sorry that I was late.
Oh, that's quite all right. We're still here. Okay, discussion. Well, I think, that's a very logical explanation on what happened, and I would like to make a motion that the zoning administrator erred, and that we should grant the short-term rental permit for this. Oh, I guess I need to say.
Effective.
The application, effective tomorrow.
I'll second.
Motion's been made and properly seconded. And I'll amend my motion that basically said the zoning administrator erred because he did not have all the information that we had today from the applicant about his health. Okay. Properly updated motion. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes. You are eligible to apply tomorrow. Good luck.
Thank you very much. Thank you.
Mr. Chairman, we had previously heard case, and forgive me for forgetting the number already, case number 2018-081. Mr. Dodd, on behalf of the Forest Hills Baptist Church, had made the presentation of testimony with regard to the special exception. The board had passed along questions with regard to the adequacy of the public meeting that had been held, and the board was trying to determine exactly what had been held and what had been invited. I've passed along to you that which has been passed along to me by the appellant, and that is 2 emails indicating email exchanges between the appellant representative and the groups that they had reached out to. That gives you some details to exactly what had been discussed, what meetings had been contemplated. You have that in front of you. I don't know if everyone's been able to receive it, but I did email each of the 5 present board members.
I've read it. Thank you.
Toward that end, I think you have the information available to at least make your determination at this point.
Okay, please come forward again. Okay, so we have the information, and so just basically tell us what the special exception's about. We'll defer all that other stuff we were talking about.
Okay, the special exception is just we're a church in a R40 zone, and have to have a special exception.
But what do you want to build, and why are you doing this?
Oh, we're adding on to the church some educational space and a indoor play area and some new entrance space and some space off of our existing gym, more sport and stage space.
How big is your lot, and how big is this expansion?
The facility is 13 acres, I believe, the whole property. Our expansion is approximately, I believe, 3,500 for the addition of the education space. And then the indoor play area is more like 800 square feet, and I'm rounding those numbers.
Sure.
And then the addition off of the back of the existing gymnasium is, I'm guessing around 25, but I'm not absolutely positive.
Are you aware of any other church in Davidson County whose place of worship has larger than 13 acres?
I am not certain, no, sir.
I'm really not either. That's a very large space, and so any questions for the applicant about this? Okay. Anything else to add?
No, sir.
We're going to close the public hearing. So I'll start off by saying what I raised the first time about the meeting, and we got the email from John Michael that did go to the Homeowners Association. It's very specifically said, you know, here's what has been put in front of us. It gave the contact information for the church and the people to do this. Although they did not, you know, have a specially called meeting, given that this went to the affected parties and they were encouraged to reach out to the applicant, I think this meets the spirit of what our law was meant to do, that they weren't trying to hide. This was discussed in a homeowners association meeting, which everyone got, you know, notified about. So I just wanted to say that, just to get that out of the way. Now, based on this 13-acre site, as Mr. Taylor said, I mentioned the Religious Freedom Act and other things anyway. You know, this is I really don't know of any other church. I mean, the church might own some just random land that their congregation is not on, but this has got to be one of the largest acreages of a church in Nashville, Tennessee, and this is a reasonable expansion. And so that's what I think. Anybody else have anything else to add? Well, with that, I would make the motion that we grant the special exception in this R40 district to renovate and construct. That's the important part. Renovate and construct a new addition to an existing church, and that they have met all the requirements of this special exception.
Second.
Okay, motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? It passes unanimously. Good luck. Thank you for coming back. Thank you, school board. Thank you, Metro Schools, for letting us take your beautiful space. John Michael, anything else to add?
Our final note is that the next board meeting will not, in fact, be the third Thursday in April due to scheduling conflicts and meeting spaces during early voting, but instead on Thursday, May the 3rd. Thursday, May the 3rd.
Early voting starts soon. Go vote.
Right? Start at 1 p.m. on that day.
Regular time. So early voting starts soon. Go vote. Thanks.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.